I think I was in the last one that you guys did together.
Hey guys, hey, we think we're live, and we're not sure, but we may just be talking to ourselves, Stephen. But I think we're live, and
That is okay as well. So welcome. Well, first of all, welcome everybody to Legal Leagues. Once again, I feel as though we've missed a couple of these shows. I know, John, you did a couple without me, and then I did a couple without you. And man, I feel like it was like the week before New Year's Eve when we did our last show, practically speaking.
I think it was a while ago. So it's good to see you again, my friend.
Good to get back on the rhythm here, man. So what's been going on in your world, John? How's things shaking out in the FCRA world, bro?
It's interesting. I just got back from a training program actually out west for FCRA lawyers, and some really good stuff out there. And we're filing, I don't know, next week or so, probably 4 or 5 FCRA cases. And so the bad guys are still breaking the law. And, I guess when they stop, I'll have to figure out something else to do to make a living. But I'm not worried about it right now.
See, John, here's the thing about you attorneys is you guys always do this word sophistry thing. You said the bad guys breaking the law. I mean, does anybody else break the law? Do good guys ever break the law, John?
We try not to.
That's right. That's right. So the bad guys are the ones who break the law. So all right, so first 4 suits you're getting ready to lay down. Let's jump right into that, man. So, what I like about you, and we were talking in the pre-show, is you are not afraid of Metro 2 factual, erroneous issues. If there's some damages and if it's a good, solid, legitimate case, you're not always looking for the low-hanging fruit. You'll if it's a good case, you'll jump into it. So, tell us a little bit about hypothetically, in the abstract, without naming names, what's coming down the pipeline in these suits. What are you seeing? What are you liking about them?
So some of the suits they follow a pattern where our client was sued in a collection case, and then we got the case dismissed with prejudice, and then months later, that account was still reporting on our credit report. So we dispute that. We give to the credit bureaus, here's the lawsuit, here's all the court documents, here's the order dismissing the case, get this off my credit report. And amazingly, they don't.
So, okay, but you did not have anything as far as that dismissal with prejudice that expressly required the removal. Is that correct?
Right. And really, a judge can't order that unless the credit bureaus are a party. So a dismissal with prejudice, you just look to your state law, which virtually every state says a dismissal with prejudice means you won. And so I got sued saying I owed Midland or Portfolio or whoever money. I don't owe them any money, so it can't be on my credit report. So we've been filing those suits for probably 15, 18 years. And then we have some more just, I guess I would call them more normal sort of status cases where, we go through and this will warm your heart to know, because we go through and say, well, hey, you're missing data these 3 months and you have this contradictory information. And, one thing, Stephen, I'm sure you've seen it. It's always amazing to me with Equifax. So, they give you the date of first delinquency, right? And that would be shockingly the date you first went delinquent, which, I'm not the smartest guy in the world, but I'm pretty sure at the date you went delinquent, that means you weren't current that month. But about half the time, you look at that date and then you go up to the little grid, the payment history grid, and you find that month and it'll have a little green check mark.
You see, it's because of attorneys like you, why they used to give previously even less complete full file disclosures. They never even used to give that grid back in the day. And speaking of which, they never still give you positive payment histories on those paper reports. Isn't that interesting? They just say like there's no data, and it'll be like 1, 2, 3, 4 CCC or whatever it is. How do you feel about litigating for lack of positive payment history on those reports? Is that anything that's ever come up?
Yeah, if it's incomplete data, what we're seeing some of, particularly with TransUnion, so we'll dispute and say, hey, look, you're missing, the following 15 things from the payment history. They'll just wipe out the payment history.
Isn't that something? They make the entire trade line even less accurate, less
Right,
complete,
right.
more misleading. Isn't
Yeah.
that something?
And the other thing is, and this is like the only legitimate way that you use Section 609, which is 1681G, is you're entitled to a file disclosure. Well,
Right.
they've got all that information, Stephen. I mean, they've got it. They just say, oh, you dispute the payment history. We're going to like take that off of the results of investigation and sometimes
Right.
off the annual credit report disclosure.
So let's
But
talk about that really, because that is, I mean, that's the core of what I talk about with the whole pre-lit, Metro 2 as the industry standard, and just looking at the data, like literally just figuring out how to read a credit report, and so you've got a client like that. I mean, that's a dime a dozen. Okay, the payment history is one jacked up way, and now it's another jacked up way, or altogether missing. What would it take for that to be, as our good friend Mike C would say, a justiciable client in your books? I mean, you're going to want to see damages, right? I mean, if I just give you a file, I'm like, John, they had kind of some Swiss cheese jacked up payment history. We disputed it. Now the payment history is just altogether removed, but the trade line is still there. Do you say, great, Stephen, let's get these people retained and throw down, or is it, well, Stephen, what are your follow-up questions to figure out if it's a case that is worthy of the John G. Watts suit, so to speak?
yeah, so we look at damages and say, were you damaged? Maybe economic damages. So you get turned down for a loan, a job, whatever. For most people, though, it's really emotional distress damages. And so the client really has to understand and appreciate, hey, you did a great dispute, pointing out every single error on that report. And TransUnion, Equifax, Experian, they just completely ignored you. I mean, like literally, Experian usually ignores the disputes. The others,
they didn't completely ignore, because they took the liberty of chopping the payment history off of the trade line. So they kind of gave you the opposite of the ignore. They kind of gave you the, haha, what are you going to do to us, huh?
well, usually what we get is like one bureau will chop some stuff off. The other bureau, let's say we dispute 10 accounts. The other bureau will say, great, we investigated the 2 accounts you disputed. I'm like, hey, genius, what about the other 8 accounts? They just ignore those. And then, somebody will just not respond at all.
Yeah.
And so we look at that and say, if you took the time, whether you, the consumer, wrote it or you had somebody else help you, nothing wrong with getting people to help you, but you approved that letter, it gets sent out, and they don't give you the respect that you deserve as a consumer to respond properly to you, that should be incredibly insulting and upsetting, because those errors mean those accounts should not be on there. And so, we file those types of cases. Now, you can imagine that, kind of in my industry, people say, well, you can't file those cases because you got to have a credit turned down. Like, you don't have to have a credit turned down. You have to have damages.
See,
Credit
John,
turned down is one form of damages. It's like saying in a car wreck, you have to have back surgery. Well, no, you might hurt your back and be a non-surgical candidate. You might have a broken leg. I mean, there's all different types of damages.
all right, so now we are really getting into we have a multi audience here, because we're piping into your Facebook. There's a lot of just straight up consumers. We're piping into my channel where there's a lot of credit repair companies. But so, I hear a lot of CRO owners, and they're like, Stephen, we put these amazing disputes together. The data is clearly wrong. It remains wrong, but we can't get these attorneys to even, like, they kind of look at us like, what are you talking about? Whereas you, on the other hand, you at least understand and you like these cases. So for the audience out here, whether you're a consumer working on your own, or if you're helping consumers with theirs. So, okay, if you start with the full credit file disclosure, the actual Bureau direct reports, and you look at it and you find all the errors, you put them on notice. 30 days later, there's a myriad of things that were not fixed. Then the next thing is you want to look at the damages, right? So in the preferable unscripted real world scenario, said consumer would then subsequently apply for credit, I would assume, because they're wanting to get credit. And I mean, they don't really know. They're not an expert. So they go and apply for credit. After the reinvestigation period ends, the dispute period ends, and then they're adversely affected, maybe not turned down, but maybe qualified for a less than favorable terms that they may have otherwise gotten had the remaining erroneous information been deleted.
Right.
Then they come to a guy like you and you're like, Mr. Consumer, you did a really good dispute because everything factual is a really like a good factual dispute. You weren't playing Mr. Lawyer like, pursuant to so-and-so case, your ass sucks. No, Mr. Consumer, you put a good factual dispute together. You put them on notice of what's wrong. That's what you're supposed to do. They didn't fix it. And then you, the consumer, tried to use your credit and you were adversely affected. So then from there, okay, what are the next things that you look at to decide if it is, assuming that there are damages of some sort that you can feel good about, what are the next things you look at to decide if it's a case that you want to work with?
Well, really it's damages. And do we have damages we can tie to the bad conduct of the credit bureaus, the furnishers, whoever is responsible? And I want to go back to something you said about, okay, Mr. Consumer, you didn't write your letter like a lawyer. Actually, I don't have that problem. When I get stuff from other people, they apparently think that there's some award to make your letter only 1 page long, to put the least amount of information in. No, put all the information in, and I mean, you can drop in like parts of the credit report and circle it. You can pull out the pages, like here's my LVNV page, and attach that to the dispute. So what drives me crazy, and you and I have been, sort of beating this drum for, I don't know, a couple of years now, is like, make your dispute letter very, very detailed.
Yeah.
And I get people who have frankly been listening to you and me for a long time, and they send me stuff and I'm like, this is horrible. I mean, I generally say it a little nicer than that. I'm like, well, we're kind of lacking a little detail. We probably need to redo that. But that's really the issue is.
So let's talk about that.
Not being done properly.
So is it fair to say that, if in fact it was a properly well-rounded dispute, factually putting them on notice of what's wrong, attaching the credit report as an exhibit, and it comes back and it's all sorts of jacked up, then they apply for credit, they're damaged, and you look at the evidence, which is a good dispute, then what are the barriers to moving forward at that point? Is there not very many barriers at that point? Are you like, Steven,
really
I wish I had that problem?
I mean, some of it, this may sound sort of odd, but some of it's just, is a person a good plaintiff? If they've got, 17 fraud convictions, probably not somebody we want to bring a lawsuit for. Will they follow our advice? Occasionally I get people that reach out to me and they say, here's the law and here's what I'm entitled to. And I say, well, actually, that's not correct. Oh, you don't know what you're talking about. Like, oh, okay. I've only been suing the bureaus for 20 years. You've watched a few videos on YouTube. How could I possibly know anything?
I watched your videos, John. That's how I know.
Yeah, never believe what I say. But isn't that what all the news guys did when they got sued? They're like, oh, that was just opinion. I'm not really a news person.
That's right.
So it's really kind of just basic litigation stuff. Okay, is this client a good client? Will they make a good impression? Do they have a story to tell that a jury will say, hey, I can see how that would affect you? Now, it doesn't have to be big damages. It might be small damages, but these kinds of cases can be brought, whether they're big cases or small cases. And so
let's back up for a second here. So all you really require is I guess you require three things. Number one is one good round of disputes, damages, and that your client be a qualified client, that they're going to pay attention and listen and be committed to the cause. Is that really basically, in a nutshell, that's the three core components of what you're looking for?
Yeah, basically, and it depends. I practice in Alabama. Sometimes people reach out to me
after 20 years. I figured you know what you're doing. Let me know when you finally when you get into actually doing the real deal.
Yeah, so I know what the law is in what's called the 11th Circuit, which is Alabama, Georgia, Florida.
Yeah.
There are some circuits that frankly have sort of weird laws on damages, mainly emotional distress, where it's a heightened standard. And so if somebody's from one of those circuits, I may say, well, hey, we need to get with the lawyer. If we're going to file it in someplace I'm not licensed, we got to get with the lawyer there anyway. But let's see, will this, will the judges accept this? And so it's really just like a battle, a game. I mean, you've got to know the ground that you're fighting on. I mean, if you're in the Super Bowl and it's in a dome versus you're in Lambeau Field and it's snowing and there's, mud everywhere. I mean, you have to know where you are, and that will, dictate your strategy. And so, but yeah, just in summary, it's, we have errors and we do great disputes. They don't fix it and we're damaged and we're a good person.
Let's back up
I
again.
sort of have a rule. See, the firm has my name on it. So I get to decide that I don't represent jerks. And so, if somebody's rude to my staff, if they're, cussing out my staff, well, hey, you can go find another lawyer.
I mean, only you can cuss out your staff. I totally agree with you, right? Nobody else should be able to do that but you, because you're the one who pays them. But all right, let's get serious again here. So if we back up, so one of the main points I was trying to drill home is you only need, from your perspective as an attorney, not a credit repair guy, but you only need one good dispute.
So let me answer that. So that's been my approach. Now, I was with a lawyer, who's very successful FCRA lawyer, past couple of days, and going through some training with him. And he is very much into multiple rounds of disputes. Thinks that makes it more likely that you win on liability, which is fault. In other words, is the credit bureau at fault? And then on damages. And I've had cases where we've had sometimes 6 rounds of disputes. Just we're trying to, give them every chance to fix it. So, one thing he recommended, and I'll be honest, I've done this sort of randomly, but not systematically, is say, have the client call Equifax and say, hey, why didn't you fix this? And do a verbal dispute over the phone. And like I said, I've had clients do that, but not in a sort of an organized manner. And so I may play around with that a little bit, but yeah, legally you only need one round of dispute.
Well, and so the middle ground would be, you do that one really good round of all the errors, which is what you and I agree on. That's what we both talk about. But then I guess the middle ground is, okay, if it's not fixed, well, you redispute again, right? And you put them on notice again. And I mean, then you are accruing those additional causes of action, I guess, those claims, because then if they start kicking things as frivolous, and you're like, well, how can I kick this thing as frivolous as being like a duplicate if literally it's still wrong, right? Or if they reinvestigate it. Let's dig into the weeds a little bit now. So,
and let me just say this, Steven, we've got some comments and we'll grab those in a minute. So we definitely appreciate everybody commenting, and we will get to those in just a few moments here.
Yeah, well, let's go. Let's just jump right in, man. Let's do it. Let's see what our audience has.
Yeah, let's see. So we've got Better Body Crew. Good afternoon, and watching this channel. So obviously, watching this channel all day would make you take lots of naps. So we appreciate you waking up for this one. And let's see, listening to tutorials, took on LVMV funding and won, but they won't take it off my credit report. Please get with me. I love those cases. So get with me, and just through alabamaconsumer.com. And I would love to see your information and chat with you. And let's see, Better Body Crew says, congrats. Sounds like you have another case. Yeah, it's very likely that you do. And so let's see. Then we have William Winston. Is an offer of judgment a good sign? So, Steve, let's take a moment and define what offer of judgment is. That's where the defendant in a lawsuit says, I make you this offer that you literally can take a judgment against me for, it might be $500 or $5,000 or $5 million. And if you turn it down and then like this is the offer and then you get less than the offer, then a lot of times there are some bad consequences to that. So that's kind of the hammer against you as the plaintiff. So is it a good sign? It means that they, have some concern about the lawsuit. And so hopefully you have a lawyer working with you to advise you on, should you take this, should you not take it? And
if he doesn't, then he can reach out to you at alabamaconsumerlawyer.com. Is that right?
Just alabamaconsumer.com.
Alabamaconsumer.com.
Yeah. Maybe I need to get the lawyer added to it. But let's see. Here's Facebook user, multiple rounds. Experian does not listen. They're hurting me. Yeah, I mean, that's something we just see, particularly Experian. And Steven, are you hearing from your credit repair folks? Are they having an unusual problem with Experian, or is it no different than anybody else?
Well, I mean, ever since really COVID, things have been wonky. Yeah, I mean, Experian is a little. They are the most difficult one to deal with. Yeah, that's for sure. Yeah, and even with the POA, a lot of times they won't send correspondence back to you. They'll send it to the consumer. So, but yeah, that's Warren, a good buddy, Warren Maxwell over there.
Oh,
so,
okay.
Reach out to John, and Warren's always cooking up these pre-cases in the kitchen. My goodness.
Let's see. Here is, I guess, Crum. How can I remove charge-offs? I had a crisis 2017, hindering me from moving forward in life and as an investor. So, Steve, why don't you take that? Maybe give us a quick overview, because charge-offs are so devastating. A lot of times they get our attention. Like, how do I fix a charge-off? So, how I know in a sense what you would say about charge-offs is what you would say about any information, but just sort of speak directly to charge-offs.
My goodness, you've completely taken the wind out of my sails. I was going to just give you the cookie cutter Metro two-step: audit the data, look for errors, and dispute them. But I mean, I guess specifically to charge-offs, though, some of the things that you can look for is the payment history complete? A lot of times there's missing periods in the payment history where they didn't report it every month. Does it show transferred and does it still have a balance? If it shows transferred to another lender and it still shows a balance, that's problematic because it should show a zero balance if it's been transferred. So those are a few things that are specific to the charge-off. Other things is your date of first delinquency. It will have a date of first delinquency, but TransUnion and Experian don't give that to you on their paper reports. Well, any of their reports, whether you get it from annual credit report or whatever. That's definitely something that you would want to dispute because that date of first delinquency is where that 7.5 year purge clock is calculated from. So those are some things specific to the charge-off that I would recommend for you to look at.
And if you'll think about, take charge-off accounts, every piece of data on that report, just imagine this phone represents each piece of data. You literally want to kind of stop, pick it up, look at it, and say, is this accurate? Is this complete? If it's accurate and complete, then you move on to the next piece of data. But if it's not accurate or it's incomplete, then you want to look at disputing that. So like I was saying before, sometimes people say, well, I was taught to only use 2 lines on a piece of paper, and so it's like a tweet or something, whatever, I don't tweet, but 60 characters or 160 characters. Now, if you need a whole page for that one charge-off, take a whole page. Well, if I have 12 charge-offs, well, then have 12 pages.
Let's talk about that tweet for a second, or that truth. We've now got Truth Social as well, right? But to the FDCPA, okay, they just did like the 600-page regulation. It's Regulation F, right, John Watts?
Right.
Which basically took a nice, beautiful 10-page law and turned it into a 600-page regulation. Let's talk about social media for a second, shall we? Because, you got to watch out what you ask for in this world. And these debt collectors wanted to have the ability, correct me if I'm wrong, to be able to debt collect via social media, instant messenger, chat, Facebook Messenger, all that kind of stuff. WhatsApp, is that basically correct?
Yeah. Email, text, social media.
So then, if you go to LBNV or Midlands or whoever, pick your flavor of choice, and you send them like a direct message in Facebook, I hereby, inform you to cease and desist every communication related to me. That's a two-way street, is it not? Is that a valid way of communicating with these debt collectors? Now we're talking FDCPA. We kind of shifted gears, but you mentioned tweet, and it got me thinking there, John.
Yeah. So two ways to describe it. If they use a method of communication to me, so they send me a Facebook direct message, they send me a text, email, phone call, letter, I can certainly respond back that same way. Now, if they don't, for example, accept social media messages, I can't just go and send them a direct message if they happen to have a Twitter account. So it has to be a way that they, acknowledge is proper for them to communicate with you. But it's a super powerful regulation. A lot of consumer advocates do not like it. I think it's actually fantastic because what it allows you to do, and then we'll get back on, FCRA, but what it allows you to do is you could send a letter, and my clients do this. They send a letter to the debt collector. They say, we dispute owing any debt to you. If you think we owe a debt, send us proof. And we give them some examples. And then we say, the only convenient way for you to communicate with me is as follows. It might be phone, it might be email, it might be text. And then we say the only convenient times are, Monday through Friday, 6 to 9 p.m., Saturday and Sunday, 8 to 5 p.m., whatever it is. And they have to honor the method of communication and the timing of communication. And so they took what was a pretty simple process before where they could call you and they could send you letters. And now it's sort of exponentially more complicated for them because now they have to monitor when they send that text message to you. You can respond and say, I don't want to hear from you by text, and I only want to hear from you by email, only at this certain email, only during these hours of the day. They have to honor that. They do not like it. But be careful what you wish for.
But just to be clear, though, this whole regulation F was really created by the CFPB. The debt collectors didn't really go out like soliciting this. Is that a fair statement? The CFPB was like, look, we're gonna create these regulations, and then it kind of just became what it became. Is that a fair?
No, the collectors have been jumping up and down, screaming about, we got this law from 1977, and we need to use text message and social media and email, and we want to be able to do it cheaply. And the CFPB said, okay. And look, that was a CFPB under Trump. Not exactly a consumer-friendly group, and it's actually pretty good for us. So let's see here. We've got a very important comment here. Great to see you guys. Even Steven.
That's our buddy Warren Maxwell. Warren, if it wasn't for friends like you, who would need enemies? Whatever, you know what I'm trying to think, man. Thank you, Warren. Appreciate you, buddy.
Let's see. Better Body Crews offer a judgment, same as a settlement. It's a good question. It's a form of settlement, but it results, if you accept it, in literally a judgment. Now, I had Equifax one time. They sent me an offer of judgment. And because, again, there's sort of a strategy on the defense side. You may be able to limit the attorney's fees or push some cost of litigation onto the plaintiff if here's the offer of judgment and we get a verdict down here. And so I accepted it. And the lawyer for Equifax said, oh, great. I'll work up the settlement agreement and send it to you. I'm like, you don't need to send me a settlement agreement. I got a judgment. He's like, what do you mean? I'm like, there's no settlement agreement. I'm taking a judgment against Equifax. And what I did for like the next 3 years was every lawsuit I would put in there, and there's even a judgment in the Northern District of Alabama against Equifax they never once breathed a word about an offer of judgment again. So we actually like offers of judgment because we flip them on the defendant to make it very painful for them. But so it is a form of settlement.
Hold on a second, John.
It's actually a judgment.
John, I hate to be that guy, but I'm that guy.
After all this lengthy absence, we're not that guy anymore. But
I am that guy. You're an attorney. You've sworn to like protect and defend and all these kinds of things and stuff and moral and all those things. And you literally just said that it inflicts pain upon them. I didn't hear anything about justice. Okay, I mean, was that like a little Freudian slip, or is that your whole existence in this arena is to just inflict pain upon the enemies and not justice for your clients? I'm a little confused as to what drives you now.
Well, those are synonyms. And hey, if we can make the guys breaking the law feel some pain, that's what punitive damages are for, to punish.
The pain is the gateway to the justice. Is that what I'm hearing? Basically, it's like,
Yeah.
oh, mercy, mercy, John, please, here's your offer of judgment, John, please, let it go, right? I hear you.
So here's we have a vote. Experian is the worst place, and that's an opinion. So let's see here. Let's see. William says, expecting a large settlement offer for my case. They only wanted to give a few thousand with arbitration. Yeah, every case is different in a sense. Now we kind of group cases together and say, well, these are identity theft cases or mixed merge cases or whatever. But it could be the case is only worth a couple $1,000s, or it might be worth $200,000. You have to know what the value of your case is to be able to sort of evaluate then whether this offer of judgment is good or not. And but I'll say this: we've gotten offers of judgment for $1,001 plus attorney's fees on cases that they ended up paying six figures on. So they give you a small offer of judgment. They're used to, frankly, a lot of lawyers are scared. Plaintiffs' lawyers are scared of offers of judgment. And they're, oh my goodness, we got an offer of judgment. What are we going to do? It's like, first of all, a lot of the offers of judgment are defective and they're not actual proper offers of judgment. And I won't go into the details because when they're defective, they have no negative impact on us. So I'm not necessarily going to train all the defense lawyers how to do a proper offer of judgment, but just get with your attorney on that. And let's see, we've got, what about lack of dispute comments by creditor collection agency? Is that a valid attack point to add when disputing? So let's break that into two pieces, Stephen. I'll take the collection side, then you take the FCRA side. So if you've notified a debt collector, or even if you didn't notify the debt collector, if somehow they know you dispute, they have to mark the trade line or the account on your credit report as disputed by consumer. That's section 1692E8 of the FDCPA. If it's a creditor, how does that come into play, Stephen? So not a debt collector, but just a creditor.
Well, they're still obligated to mark it as in dispute. I mean, it's part of the industry standard, Metro 2, and I mean, they have a duty to report maximum possible accurate data. So if you've disputed it, and I mean, so you're not going to have that FDCPA, that E8 component that John's talking about, but still it's inaccurate right now. I mean, the problem with that though is you don't have the FDCPA, so you're just using FCRA, and so you just have to add that to the big giant pool of errors that you're arguing to the judge. But absolutely, whether it doesn't matter what type of trade line it is, it needs to be reported as in dispute, just to conform to accuracy requirements and their industry standard.
Yeah, good point. Good point. So now we have something which you have mentioned, this weird thing about Metro. And so Bryce has this very good question: Metro or factual preferred choice? And so I shared this with you, Stephen. Let me pop this back up. So this is a video that is from January. It's got John Olsheimer, who is a very frequent, probably last 20 years, been an expert for credit bureaus, furnishers. David's got the, what's it called? Credit Versio, I think, software. And then Steve is a former TransUnion guy who, I don't think he owns Smart Credit, but I think he's like their public facing guy, right? For Smart Credit.
Yeah, he's like their chief marketing officer or something like that. Yeah.
And so this is a video about, well, let me remove this comment here. You can see it's kind of hard, but are Metro 2 compliance disputes legit? Let's ask experts from the credit bureau. So I'll even drop the link in case somebody wants to watch that. But so why don't you first, let me put our comment back up there. Why don't you first explain what is Metro, and we typically call it Metro 2, and then maybe you can define what most people mean by factual dispute. And
Sure.
is that the same? Is that different? And if it's different, which do you prefer when you dispute errors?
Well, so I guess the way for me to start is that there's different people that mean different things when they say Metro 2 compliance. I mean, there's a bunch of people out there. There's a software company, and they spit out some letters that I can't really speak for what they do or how they market their thing. So what I say when I talk about Metro 2 and factual, really Metro 2 from what I teach people is really just the basis for saying it's factually inaccurate. So from my perspective, Metro 2 is the industry standard. So let's back it up for a second, okay? So all I can do is speak to what my understanding and how I teach folks. So the FCRA requires accuracy and it requires procedures. It's important to understand that. So like it requires reasonable procedures to assure maximum possible accuracy. And so that's super important to understand. That procedure clause is part of the maximum possible accuracy. And so, the precedents are very clear that if a credit bureau does not follow its own procedures, it just got a problem because the law requires it to follow procedures because it requires procedures. So Metro 2 is like the bridge between the reasonable procedures and the maximum possible accuracy. Okay, there is no other bridge out there because accuracy is not defined under the FCRA. So Metro 2 is designed as their industry standard for reporting maximum accurate information. Excuse me. So Metro 2 is a data format. Basically, it says you're going to have a balance, a date opened, a date closed, a date of first delinquency, your credit limit, your credit high, all these fields. It's basically a format for your data. So the law requires reasonable procedures, which they've created Metro 2 as their standard, which is you have to have procedures to follow your industry standards to assure maximum accuracy. So from my position here, Metro 2 is really just a way of saying this is factually wrong, but here's why it's factually wrong, right? Because without Metro 2, you may think it's wrong, but it may actually not be wrong, right? If you don't have the rules of the ball game. So as an example, I mean, you may look at something and say, well, this is factually wrong because it's missing this piece of data, or this piece of data is reporting this way. But we don't know. We're kind of just using what we think and what we feel to assess it. But there is, in fact, an industry standard with a set of rules. So that set of rules coupled up with the factual, which is really just looking at the data, then you can make your argument and say, Mr. Bureau, this is factually wrong. And more specifically, I'm telling you it's wrong because based on your own industry standard, Metro 2, you state that it should report this way, but it's reporting that way. And so that's what I would say to you is really Metro 2 is it's really indistinguishable from factual when you look at it like that. There's other folks out there who say, Metro 2 compliance, and they're sending letters trying to like trick eOscar and how to do all these kind of crazy things with the computer system, but I can't really fully understand how that works. But Metro 2 is an industry standard. It's a data format, and it is the bridge that bridges the gap between reasonable procedures and maximum possible accuracy, if that helps, Bryce.
Yeah, that's good. And I'll just add from my standpoint as a lawyer who sues the bureaus and the furnishers, Metro 2 is not the law. It provides, as Steven said, the industry standard. Now, if they violate the industry standard, that may help us to show that they violated the law, but it doesn't guarantee it. The flip is also true. Sometimes they go, hey, we followed Metro 2, and we're like, we don't care. Metro 2 is not the law. This is still inaccurate. This is incomplete. And so if you watch that video that I put up with John Olsheimer and David and Steven, not our Steven, but
not this Steven, the other Steven.
Smart Credit. They pop up an example of sort of a Metro 2 compliance letter. And as Steven Palmieri said, I mean, people have all different definitions of Metro 2. So sometimes people get in these massive arguments and they're talking about two totally different things. It's like we're having an argument about the rules of football, and Steven means, American football, and I mean soccer in Europe, and we're like yelling at each other. It's like we're not even talking about the same thing. So from my vantage point, I've seen some of these what appear to be Metro 2 compliance letters that have all this weird language in about, this. I can't even really understand it. And the point I'm bringing this up is that may be great from a credit repair standpoint. That may get deletions. It may not get deletions. The advocates and those who sell sort of Metro 2 compliance will say this is the greatest thing to get deletions. From a litigation standpoint, if my judge is reading the dispute letter and has no idea what these words mean, then they're going to be very reluctant to hold the bureaus liable. And so, some of this is, at least some that I've seen, it's like the words are jumbled up. It doesn't make sense in the English language. And so my only point is, from my standpoint, I'm not doing credit repair. I'm helping people dispute stuff. If it doesn't get fixed or deleted, then we sue. So that's my mindset, which may be totally different than a CRO who says, hey, I don't care whether we could ever sue on this. I just want something that may help get deletion. Well, maybe it works, maybe it doesn't. I would watch that video with John Olsheimer. I've watched, 15 minutes of it. And you'll get sort of the perspective from a guy who not represents as a lawyer, but as an expert witness, all the bureaus and a lot of the furnishers. And you'll get Steven from Smart Credit, who was really the head guy for disputes for TransUnion for many, many years. And so I think it'd be wise to listen to them. Doesn't mean you have to agree with them, but listen to them and then decide what's best for you. Let's see.
Excellent point, John. Excellent.
Thank you. So somebody canceled the missing person report for me. Well, I appreciate that. It's very kind.
Where have you been, John? Where have we been, huh? Did you ever fix this on your calendar? You haven't.
Yeah. Actually, I fixed it so well it was on there twice for today.
Good. That's good. All right.
Let's see. So here's a good one. Steven, do you offer classes or one-on-one mentoring for credit repair?
Yeah, absolutely. Go to creditrepairtrainingcourse.com and we give a 30-day free trial. It's $99 a month. In fact, that's where John and I met. I had started the course in this group, and we kind of met through that. So go to creditrepairtrainingcourse.com, plug in. I'll reach out to you directly, get you plugged in, get you set up. We have an awesome Facebook group, which John is in as well. And we've got weekly lives.
Look at that guy.
Look at that right there.
Like a glamour shot.
That's back when I used to fit in my suit before COVID. So, but don't tell anybody that, So, but yeah, so just go ahead there, creditrepairtrainingcourse.com, plug in, 30-day free trial. If you like it, cool. If you don't like it, cool as well. And definitely looking forward to helping you sharpen your game on that.
Yeah, so here, just creditrepairtrainingcourse.com, and you'll see this guy's face, and he'll help you out.
That is a good looking face, though, John. You got to admit.
Yeah, you're right. So,
That's right.
All right, let's go back up here, and let's see. Paid debt buyers in 2019 for I knew my rights. Now I think they did not own the debt. May I get that money back from them? Generally, no. If you settle, everybody kind of takes their chances. It'd be like, let's say a credit bureau settled with you in a Fair Credit Reporting Act case, and then later they go, you know what? We think we would have actually won that case. Well, they can't get their money back. So what I would say is just make sure that those debt buyers are not on your credit report, or if they are, that shows a zero balance. And sometimes they will show a balance more than zero. And if that happens, you can have some fun with them, and you will probably get back more money than you paid them. You'll get back in a lawsuit if you're successful. Let's see. Oh, I think this was kind of a duplicate one. So yeah, so Stay Focused 254. Just go to Credit Repair trainingcourse.com.
Yep.
And Steve will jump on a phone call with you. And let's see. When sending disputes, do you send the whole screenshot of the whole account to all three bureaus? So that's a very, very good question. And let me sort of set the scene here, and then we'll get Steven to fill in the details. Some people send one letter to all three bureaus. And so it'll say like Capital One account 1234 opened on January 1st, 2017, balance of, and then they'll say Equifax, blah, 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 blah. Experian, blah, 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 blah. TransUnion, okay. Other people will just have one letter to Equifax about that Capital One account, and then they'll have a separate letter to Experian about Capital One and a separate letter to TransUnion. So, Steven, first of all, I guess tell people which approach you take and that you recommend, and then maybe for both approaches, would you put the whole screenshot in of all three accounts? Would you only do one? What would you do?
Sure. Well, so I will put all three bureaus in one letter. And the reason is because they all use the same identical industry standard, which is Metro 2, right? So people say, oh, well, but they're different companies, which they are, but they're bound to the FCRA, which is maximum possible accuracy. And they all conform, or are supposed to conform. They all have adopted the same industry standards. So from tying into what I had explained earlier, being that Metro 2, if you look at it like the bridge, I'll take, the Capital One, put that in one letter and say, well, it's reporting a $500 balance in this bureau and a $0 balance in this bureau, or the limit was this in this bureau and this in these two bureaus. You guys all use the same industry standard, so I'm confused. It's your data, it's your standard, it's your company. Give me my industry standard accurate report or delete it. That's my approach to it, and you basically kind of use their industry standard and their own inconsistencies essentially to checkmate them. The only reason I would see sending a letter individually to the bureaus, if you really are trying to do maybe something laser focused and get something corrected, perhaps it's like, well, this bureau is showing a $500 balance. I've got a letter from American Express dated 3 days ago and it shows that it was paid off. The other two bureaus are showing paid off, so really there's nothing there, but you want to send it to this one. But if you really are going in and disputing it and trying to find errors and put them on notice of errors, almost religiously, I send it to all three bureaus. And that's kind of the reason why I would do that.
And so in that letter that lists Equifax, Experian, TransUnion, assuming all three have errors, if you did the screenshot approach, would you put in the whole account or just the parts that you're disputing from, say, Equifax, Experian, TransUnion?
Yeah, I'll put in the whole trade line. And if you're pulling individual reports, Equifax, Experian, TransUnion, I'll put each one of those. I don't put the whole credit report, but I'll put the entire trade line for that account in question in the letter. And the reason being is, the credit bureaus, their reinvestigation procedure, again, they have to have reasonable procedures to assure accuracy, but also reasonable procedures when reinvestigating. And we all know that what's in their computers is going to be different than what's on the paper printed out reports. So if you are putting them on notice of your dispute and give them a copy of their own credit report, it's a much more solid report, because they can't come back, like if you hand it to a guy like John, and John were to sue them. They can't come back and say, oh, well, but we looked in our computer and it looked accurate. And how can you say we didn't look in our computer and it wasn't accurate? You know what's in our computer? No. And you didn't give us the credit report. So, who are we to say that it was reporting inaccurate? Whereas if you put that in there, again, the spirit of the FCRA dispute process is to put them on notice of errors. That's really the spirit of it. And to force them to not throw your letter in the garbage can, which is, as ironic as it is, that's before the FCRA, there was no dispute mechanism, right? So it created this ability for the consumer to say, hey, Mr. Credit Bureau, I think there's a problem, and here's why I think there's a problem. It wasn't really designed to scrub credit clean. Although it's a good mechanism to do that because their systems are so flawed, right? There's errors all over the place. You can do that, but keep in mind, you've got a better chance of scrubbing it clean if you can really put them on notice of what's really wrong, right? If you Send them a letter, but there's nothing wrong. You don't deserve to get it scrubbed clean, right? I mean, because that's not the law and that's not the way it's supposed to be. But because their data is so jacked up, if you can put them on notice of how their data is so jacked up and they continually disregard it and don't fix it and don't delete it, so John, you and I, before the show, before we started the recording, we were kind of talking, and I guess we were talking in the early part of the show that a lot of disputes that people come and give you disputes, and they're like, John, here's my grievance. And you look at their disputes and you're like, man, this dispute is kind of garbage. I mean, you're telling me this thing, but your dispute letter says absolutely nothing about what you're telling me now. Why didn't your dispute letter describe your complaint that you have now, right? And so, I mean, if we can think like that, we want to put our argument on paper. We want to back up our argument. And what's the best way to do that? Well, if their own report is wrong, and then how can you validate that their report is wrong? Well, then you look at their industry standard manual, which is Metro 2. And if it says it should report this way, and then the report is reporting an opposite way, and you put that on notice to the bureaus, now you have a dispute with supporting evidence that you can give to a guy like John, and he'll say, oh, what you're telling me now is actually in alignment with what you told the bureaus, so we may not even have to redispute it. Whereas a lot of people go to John and the disputes don't say at all what their current complaint is. And John's like, wow, I appreciate you spent 6 months of your life sending letters, but I'm going to have to start from scratch now, right? So there you go. That's what I would do, is I would include the screenshots of what's wrong for each bureau in the letters. And for all those reasons, that's how you build really a good case file, I would say.
Yeah, and it can be a screenshot where you literally like embed it in your Word document or your Google Doc or whatever, or it may just be an attachment or an enclosure where you just pull out the page from Equifax, page from Experian. Sort of the mindset of this is to say, what are all the crazy excuses the bureaus could use to not investigate your dispute? So they say, well, Steven, we don't think it's really you. You enclose your driver's license. They go, well, we don't think that, this is really you because we think maybe you stole the driver's license. So you're like, well, here's my power bill. Here's my utility bill. Here's my State Farm insurance bill. Okay. And they're like, okay, well, we can't do that. Then they go, well, we didn't know which Capital One account you were disputing, And well, see, if I enclose the account, then they can look at it. And it's sort of a hard excuse to say, or a bad excuse to say, well, we didn't know which one you meant. Oh, and those like 10 pages of credit reports that I included, that didn't give you a clue? Oh, well, we didn't look at that. Well, that's their problem. Okay. That's a lousy investigation. So, I think that however you do it, whether it's attaching them, embedding them in the Word doc, and I'll say this, sometimes I don't do this because maybe it's just one account, or maybe it's very clear what we're talking about. And so we describe it in words. Okay. But I do think it's probably better to enclose the credit reports. And again, you're just taking excuses away. So let's see. Hero and Professor. Well, remind me and I'll send you the money for that very nice comment.
Frame that one.
The Punisher. Well, but punitive damages. All right. So here's an interesting question. And so we'll have Steven elaborate on this. Does an inquiry where somebody has accessed or pulled your credit report, does that need to be marked as disputed? How would you answer?
Under the plain language of the FCRA, it can be reinvestigated because 1681I says if an item of information contained in the consumer's file is inaccurate or incomplete, the consumer can dispute it. It says an item of information. And guess what, John? Last I checked, an inquiry is an item of information on a consumer report in plain English. So then from there, if you dispute it, well, one would think it should be marked as in dispute. So that's my official answer. And then, of course, now, John, the reason why you get paid all those six-figure settlements is because you don't play in the game, the sandbox of plain English. You play in the sandbox of case law, Which
So-
basically means you attorneys take plain English and bastardize it and turn it into something entirely different. So John, tell us why I'm entirely wrong here. Go ahead, buddy.
Well, I mean, I always enjoy telling you that you're entirely wrong. This time, unfortunately, you're pretty accurate. I will say this:
I'll send you the check in the mail. Then,
Yeah.
you know.
So, but what Steven said is very important. Where he said information. Okay, so let's look at a couple things here. Let me just pull up. Let's see here. Let me share this. Oops. I was like expanding the wrong screen there. All right. So 1681I, this is, think of I for investigation. This is where you can dispute information. Okay. And so if the completeness or accuracy of any item of information. So let me give you an example of where this has come up, where there's an argument over, well, what does information mean? So there's a particular strategy. I neither endorse nor reject this strategy. I just observe this strategy of basically you dispute an account, and so it's marked as disputed. Well, if it's marked as disputed, you can't get a mortgage loan, okay, because it typically hides that account from the credit score. And so you have to sort of get it undisputed. So how do you do that? Well, there were some people filing lawsuits that would dispute the dispute status and say, I know.
Irony, right, John?
What's that?
The irony, right?
Yeah.
I'm disputing the dispute, but I don't want it to be disputed even though I'm disputing that.
Yeah. And so a lot of judges kicked those out. And some judges kicked them out because they said the dispute status is not, Stephen, an item of information. And a judge where I practice, her name is Judge Axon, appointed by President Trump. She's a very thorough judge, and I've gotten good orders and orders that I disagreed with her on. But I'll say this: very, very thorough analysis of the law, very detailed analysis, and she's rejected that. She's like, no, it's a information on your credit report is literally information. I mean, if it's on there, it's information. At least that's my interpretation of what she said. And so she allowed one of these cases to move forward, even though a lot of judges are rejecting them. And there's a mentality among a lot of judges of, oh, well, if these three judges in Oklahoma ruled in favor of TransUnion, I'm not going to sort of stand in the way of that. She goes, no, I've looked at the analysis. I don't agree with it. Okay. So I bring that up to say, on this information, I think she's absolutely right. We've always taken the position we can challenge an inquiry if there was not what's called a permissible purpose. Okay. We won't go into all the details of that. That's pretty complicated. But it's not that the inquiry would be marked as disputed. Either it's valid or it should be deleted. There's no middle ground there. So either it stays because there was permissible purpose or it's deleted. And so hopefully that is.
So, and keep that up right quick there,
Okay.
John. So even to your point, if they're saying that a certain set of data within the trade line is not a quote unquote item of information itself, what is you have highlighted right there? It says if the completeness or accuracy of any item of information. So that dispute notation is a component, which clearly would be a component of the completeness or accuracy. And then, I mean, their duty is to modify or delete it. So now really what you're saying is certain judges have defined the word item to not
information,
an item of information. Yeah. So, but that also goes to show you that, precedents are not always fixed and set in stone, right? I mean, the law is constantly changing. The interpretations are constantly changing, and and this goes back to Metro too. I think somebody had posted up a comment. I don't know if we put it up on here, but they said that the precedents have basically said that Metro 2 is not the law; it's an industry standard. Well, that's definitely true. I mean, it's not the law, and it absolutely is the industry standard. But if you know how to tie it together as that bridge, right, and properly argue it, you can say, well, if you cannot use the industry standard as the definition of accuracy, what can you use as a definition of accuracy? Because accuracy is not defined, right? So it's really, how do you create your arguments? And if you can create an argument and you have a good fact pattern, you can overturn precedents. That's really kind of the takeaway there, right? So
yeah, and sometimes this gets into the weeds, but going back to this just as an example, this idea of it's disputed and then I dispute the dispute. So I'd say to TransUnion, look, I no longer dispute this, so the information is inaccurate. The 11th Circuit, which is the appellate court over Alabama, Georgia, Florida, ruled against a consumer for this. And they were pretty critical of the dispute letter and said it was very confusing and hard to understand. And so basically, sort of reading between the lines, they said, we're not going to hold anybody liable if you send a lousy dispute letter. And they at least suggested that you should have to go to the furnisher privately and tell them you no longer dispute it. And then you could dispute the dispute through the bureaus. Well, Judge Axon in this case said, well, that's not in the statute. So in that opinion from the 11th Circuit was what we call an unpublished opinion, which means it's not binding on the trial judges, the district court judges. And so the judge in Alabama said, I don't find that it's binding on me. And so the point is that sometimes we do get into kind of the weeds here. Okay, well, is there a case that seems similar, but maybe it's not quite as similar as we think? Or, what is this argument about an item of information? And so this is, I've mentioned this on some of my webinars I typically do on Thursday. I couldn't do it today because I flew in this morning, late last night, this morning, and it was just sort of a crazy day for me. But if you're going to sort of play in this arena, you've got to do the work, and don't believe somebody when they say, oh, here's what the case law says. Go read it. Steven, who's the guy that is very knowledgeable about TSR? Is it Robert
Sigmund? I think he's watching us over here. Yeah.
So, I mean, look, Robert, if you go to his website, I mean, he's like dissecting the statute, the case law, and whether you agree with him, don't agree with him, he's putting in the work. Okay. And there's a lot of people that want to sort of be at a mastery level, but they want to put in amateur hours. And if you want to be up here, you got to put in the work. And there's no particular shortcut. You know
where I come from, John. We say that's a champagne appetite on a beer budget.
Very good, very good. So let's see. I've never found anything about marking inquiries disputed. Yeah. So yeah, I think that's right. It's not marked as disputed. Either they're wrong and they're deleted, or they're right and they stay there. Let's see. How do you avoid the 15-day extended dispute time when using annual credit report? I'll say this. We always use annual credit report. And with the exception of Experian, who often doesn't respond to disputes, everybody else responds in 30 days. And now, whether they could take 45 days, they just don't do it. And we will allow for that 45 days because in my world, I want to see the credit report before the disputes that led to the disputes that then leads to the results of investigation. And then I want new credit reports pulled from annual credit report. And that gives me the full picture.
So let's talk about that.
Beyond 45 days anyway.
So let's talk about what you just kind of touched on there. So obviously kind of right now for COVID, you can get a weekly annual credit report, but apart from COVID, you have to pay for it unless you get one a year. You get one a year and you have to pay for more frequent ones. Now you had said that Experian oftentimes doesn't respond. So what is your legal pathway through, the journey of getting the fact pattern to where you put that lawsuit together? I mean, so you've got an annual credit report that you pull online. You put your dispute, you send it out, you do not get any sort of reinvestigation results from Experian. Do you just go and pull an updated annual credit report like a month and a half later and you're like, okay, well, we're going to litigate based on this, even though we didn't get the results? We don't know if they reinvestigated. We don't know if they didn't reinvestigate. We don't know if they reinvestigated and didn't mail us. We're just going to throw all these causes of action in. How do you handle that scenario? Because that's really common for a lot of folks.
Yeah. So what we do, if you think about it this way, there's really, for the most part, 3 areas of the FCRA that we sue under. And there are more than this, but these are the big 3. So Section E that I have on the screen, which you've heard Steven talk about, this idea of reasonable procedures to assure maximum possible accuracy. So that is right here. So this is only for the bureaus, has nothing to do with the furnishers, only the bureaus here. And so we would bring this claim. Now, this is not a disclosure. This is an actual report here. Okay. So yeah, it says Consumer Reporting Agency prepares a consumer report. So that means it's somebody other than you. And so we have to have that. Up until last year, there was one part of the country they did not have to have that, but the U.S. Supreme Court sort of closed that door to no, you have to have this disclosed. So we could definitely sue Experian under this as long as we have a what's called a publication of the credit report that to somebody other than just to my client. And because we notified them, particularly after the dispute, they knew, hey, there's a problem, and they chose not to use maximum possible procedures. Now, the next section that we go to is I for investigation. And this requires the credit bureaus to investigate. It also requires them within 5 business days, to send a copy of your dispute, unless they're just deleting the account, to send it to the furnisher. Now, did they do that? Did they not do it? We don't know when we sue them. I mean, we'll find out once we sue them, but we don't know. So if Experian did not investigate it, did not send it to the 8 furnishers that we disputed, well, then they definitely violated this section. Okay, assuming we have actual inaccuracies we pointed out. Well, then we have S2B, which is for the furnisher. And so, and I know you know this, Stephen, there's Section A that sounds fabulous and has wonderful language in it, and you can't sue over it. So we go all the way down to somewhere here will be B. I always think I passed it when I'm doing this because you have to scroll forever. Somewhere.
You're getting close. You're almost there, John. Almost there.
All right. There we go. All right.
Almost there. There you go.
And this really tells you what you need to know. Duty of furnishers of information upon notice of dispute. And that's from the credit bureau. Okay. So you can notify them all you want. Doesn't matter. The credit bureau has to notify. So let's take the example of Experian or whoever it is. They don't do any investigation. They don't notify any of the 8 furnishers that we disputed. Well, we can't sue the furnishers because they weren't notified by Experian. But all that fault now comes crashing down on Experian. Had they notified the furnishers, Experian would still be at fault if we've identified actual errors, but the furnishers would be at fault too. So sometimes we just sue the credit bureau and we say, give us your documents. Did they notify the furnisher? Did they not? But usually we just sue everybody. And if the furnishers come up and go, hey, nobody notified us, we go, hey, swear that under oath and help us go, just attack the credit bureaus.
So let me ask you, John, so in that case, I mean, can they try to recoup like attorney's fees from you guys if they're saying, well, you sued us for this thing, but it was never triggered? I mean, because obviously it's a sticky situation because you don't know if they were actually notified or not until you sue them, right? So how does that work in the real world?
So let me show you this. Federal Rules of Civil Procedure. And we'll go to Rule 8. And most states have the same thing. And so this is how you plead a lawsuit. And so somewhere down here, it's toward the bottom, will be right here. If you look at these two sections, particularly the subsection 3, so you can set forth statements of claim or defenses alternatively, hypothetically, but inconsistent. A party may state as many separate claims or defenses as it has, regardless of consistency. So people get thrown out of court if they don't plead that Equifax, Experian, TransUnion, whoever notified the furnisher. But maybe they didn't. So what we do is we put one paragraph that says Equifax notified each furnisher. The next paragraph, alternatively, Equifax did not notify the furnishers. Experian notified the furnishers. Alternatively, and we say we don't know, but we'll find out when people start swearing under oath. And so, because there's no way for us to know that until we get people raising their hand, swearing under oath, there's no problem with pleading that alternative.
Okay, so what you're saying, though, I mean, like, because I guess the way the statute is structured like that, I mean, if you sue a furnisher 1,000 times and they were truly never notified 1,000 times, they just have to deal with their attorney's fees up until the point of them saying we're going to swear under oath that we were never notified. And they can't have any recourse to try to recoup. That's basically kind of what you're saying.
Well, they may have they would have an agreement with the credit bureaus. Often it's called a subscriber agreement, and that may allow for, hey, if we do something, like we, the bureau, do something wrong, you can get your attorney's fees back, or vice versa. But it's not coming back on us.
Yeah.
And now I will say this: sometimes you can tell in the results of investigation. I'll say we contacted the creditor, and they told us, well, that doesn't mean it's true. It means Equifax says that. Did they really? I don't know. Did they do it within the time limit? I don't know. And so, but I will say this, usually they do notify if they send you results of investigation. So let's see here. We've got somebody invited, Fourth Gen Mayhem. So welcome to the show here. Hello. And okay, courts have ruled that about Metro 2 just an industry standard. Yeah, it's right. And I'll say this. So my background is I do personal injury. So we might be suing a trucking company. Well, guess what? We're going to use their industry standards, because the industry will say, well, here's what being a reasonable, non-negligent trucking company means. Well, that's not the law, but it certainly is better when you get the safety rep for the trucking company and say, now, you agree these are the industry standards, and you agree that your company violated these. Yeah. It doesn't prove absolutely that they broke the law, but it's pretty stinking good evidence.
Except when you're dealing with the credit bureaus, you say, you agree that these are the industry standards. Yeah. You agree that you violated these industry standards. They say, no. They never say, yeah. They always say no, right? We never violated anything.
So in a lot of ways in litigation, we don't really care what the other side says. We'll ask them questions where they either admit it or they look like an idiot. And what do I care? So
you're not in it for the popularity contest, is what you're saying, huh, John?
Yeah. It's like we had a debt collection trial. We sued a debt collector, and it was in federal court. We're trying the case, and I said in opening, I pointed to the representative of the debt collector, and I said, she's going to get up on the stand and tell you any honorable debt collector that realizes it broke the law would apologize to the consumer. I said, I didn't care if she agreed or didn't agree with that. And her lawyer gets up and goes, apologize. We'll never apologize for anything. And I'm like, wow, that's better than I imagined. So if she agreed to it, that's great. If she refuses to, what do I care? So a lot of times we structure our questions so we're telling our story, and we frankly don't care what the Equifax representative answers, because we're telling our story to the jury. So let's see, keep it simple and plain. So yeah, I think on your dispute letter, and remember this, a dispute letter, one thing that has helped at least some people that I've said this to is imagine you're sitting at your dining room table, and over there you've got Equifax, Experian, TransUnion, Capital One, whoever, and they're like, "Okay, you called this meeting, Stephen. What's wrong?" And you go, "Well, Equifax, I'm really confused because you say the date of first delinquency on the Capital One is June 2018, but in your payment history it says June, July, August 2018. I was current. How can that be?" And well, so you can ask questions, okay? Just think of it like you're having a conversation. So it doesn't have to be any type of fancy language. I mean, I prefer simple language to, you know, people use fancy language are only doing it to try to impress others. And for most people, that comes across as it really makes you sound stupid when you use unnecessarily complicated language. So, yeah, keep it simple. So let's see, fourth generations in the Lone Star State there, which I think Steven Palmieri knows about that state.
Wearing my Texaholic shirt. You see?
There you go.
That's right. We love
See,
the Republic of Texas.
we got Bryce. Thank you. We got Carolyn. So glad you're here, Carolyn. And let's see here. Aaliyah. Hope I'm saying that right. Yeah.
John, we got to crawl up above this thing here. We can't see what's going on.
Let me see here. I'm making. There you go. Now at least our foreheads are showing. Let's see. Live in Georgia. Have a question pertaining to DirecTV. Had an account with them. Had an additional box. Wasn't told nor made aware of contract of equipment. Active military renting. Landlord sold home. We had to move. Didn't want to continue with them. They submitted account to credit reporting agency stating I never paid and asked several times for the contract. And sorry, Soling. No, it's no problem. We're glad you sort of put your message out. So what I would say, two things about DirecTV. It's probably not DirecTV that, pardon the pun, is directly on your credit report. It's probably like Enhanced Recovery or IC System or AFNI or some collector. I would ask the collector for the proof about what they say. Whether it's you didn't return the equipment or you canceled it before your contract was up or whatever. You can also write to DirecTV, which is AT&T, again, directly to them. And if there is a problem, I mean, if legitimately this is incorrect, you can look at suing the collector because they're collecting a debt that's not owed. And you file an arbitration against AT&T, which has the most fantastic arbitration agreement of any company, okay? And you have to submit what's called a pre-arbitration dispute. And if they make you an offer, but by a certain time, and then you exceed that offer, you get either the amount of the award or $7,500, whichever is more. So they might offer you $500. The arbitrator gives you $700. Boom, you're getting $7,500 for that. And even if there's no provision in the law for you to get attorney's fees, your attorney will get attorney's fees. And then AT&T says, but that's not all, Stephen. We're going to double your attorney's fees. It's the greatest arbitration. They do it because they don't want a class action, and they want to say, look, we've made this beyond fair for the consumer. So my point is, figure out if you really owe this debt, if they've done everything right, and think about writing to the collector, writing to AT&T. And we do a lot of these. So if you want to reach out to me, just alabamaconsumer.com, and I'll be glad to kind of walk you through it. Here's a good one for you, Stephen. Social Security number is wrong at one of the credit bureaus, and they have 25 addresses. I'm assuming maybe some of those addresses are not Victory Empowerment Org's addresses. What should be done on my end? How would you answer that?
Yeah, well, I would put it in the form of an affidavit, and I would say my true, correct, and only Social Security number is whatever that is, and my only address is, and put it in there. All other addresses are misleading and inaccurate because they'll they're not associated with me and have no bearing on me, send that as an affidavit to the bureaus. And if they don't fix it, make a beeline to John G. Watts, AlabamaConsumer.com.
So here's the other thing I would add. If the addresses are old addresses, but they used to be yours, you may want to say that, like, these used to be mine, but I haven't lived there in 10 years. I don't want solicitations going there because I might be the victim of identity theft. But if they are addresses you never had and they have a social security number that's not yours, they may have mixed your file with somebody else. And so I think I looked one time, Stephen, there were like 5 John Watts in Alabama. Like, who knew? I thought I was the only guy. There's like, maybe they're new improved versions of me. I don't know.
And interestingly, they each had versions of your website. One was alabamaconsumer.info.
Yeah.
Alabamaconsumer.org.
It's
a
very
coincidence, huh?
Very sore subject. I really dislike you for bringing that up. So it could be that you have this mixed merge file, in which case it may be better to even go ahead and sue before disputing. Sometimes we do that on a mixed merge file. Typically, you'll see that it'll just be one credit report that has that. And so if you want to reach out to me, I'll be glad to chat with you.
See, John, there you go. You take all the fun out of it. You file suit before you have the chance to trip them up on a perfectly good dispute chance. You just like, you lose the opportunity to slip them up and trip them up. And
sometimes we do both.
Oh.
We may do a dispute and also sue. And
what you're saying is you're going to dispute it in the form of a complaint, of a lawsuit. You're like here's my 1681I just served in the form of a lawsuit to your legal department, right? Basically, because the FCRA doesn't say you can't dispute it in the form of a lawsuit, technically speaking, right, John?
I guess technically speaking. So here is Sir, I guess, yeah, okay, that's clever. Surreal Sunstones, okay, very clever. Have you ever sued third-party debt collector pursuant to UDAP, which is typically unfair, deceptive trade practices? So in Alabama, the answer is no, because our statute is pretty miserable. In Georgia, yes. Georgia has a fantastic statute. It's called the Fair Business Practices Act that basically says, and there are exceptions, but basically says, if a debt collector violates the FDCPA, they have violated the Fair Business Practices Act, and it may treble your damages. So it's a pretty cool law.
But I mean, FDCPA is essentially a UDAP type statute, is it not?
Yeah, in a sense. And so like in Florida, there's a Florida version of the Fair Debt Collection Practice. It's not everything the FDCPA is. It's parts of it, and it applies to original creditors. So every state typically has one of these laws. Some are great, some are terrible. So yeah, we have done that, but typically we also would bring an FDCPA claim. And let's see, this is going back to our direct TV. If all 3 bureaus show something different, how do I begin dispute? So why don't you give the quick version of when you find...
Yeah, sure. So we had touched on this earlier if you watched the replay, but basically what you would want to do is draft a letter for that trade line, send it to all 3 bureaus and compare the data, so the balance is this way for the 3 bureaus as an example. So put all the errors from all 3 bureaus on one letter and then mail that identical letter to the 3 CRAs. That's really where you would want to start with that. And also attach a copy of the image of the credit report trade line from each bureau.
Yeah, showing those discrepancies, how they have different stuff. So that'd be a good idea. So here is American Credit Acceptance made a settlement for $3,000 for my car during COVID. They haven't sent me the title yet. So that's kind of state law specific, but I've had that maybe one time, and I just had my client write a very detailed letter, and maybe I wrote it for him. I can't remember, Stephen. But basically just saying, hey, here's what happened factually. We had a dispute. You said if I paid you $3,000, we were done. Where's my title? You are, preventing me from selling my car, refinancing my car, whatever. and I want the title. And that may be what we call conversion. And that's when somebody deprives you of something you're entitled to. It may also be there may be a specific state law violation, like a company has X number of days in your state to give you the title. In other words, they can't just say, "Hey, Steven, thanks for paying off that BMW you bought last year. We're never giving you the title." They can't do that. And typically, a letter with certified mail. And remember, certified mail, there's no good news comes by certified mail. So certified mail is the person receiving certified mail says, "Oh, the one that sent this to me thinks I'm going to lie, and they want to prove that I got this letter." It really escalates. It's way more than an email. I mean, it's the fact that it's harder to do gives it more weight, gives it more of an impression on the other side. So that's what I would do. Do you have any insight into car titles, Stephen?
No, I mean, you lost me at the certified mail indicates you thought I was going to lie. I think that's amazing.
Yeah. So I'll send you certified mail for our next show. All right. So, since monitoring service aren't perfect data like a paper report, can you use monitoring service info or avoid it? Only include screenshots from paper reports. So I'll say this. When you're saying paper reports, I would say anything from annualcreditreport.com. Okay. It could be an online version. It could be they're mailed to me. That's going to be the most accurate. There's sort of a weird thing. I know this will sound bizarre, but like if you go to myequifax.com, technically that's not the Equifax that we see. If you go to transunion.com and buy something, you're actually getting like the subsidiary company. And they have argued in cases, hey, that's not our data. That's somebody else. That's like the subsidiary TransUnion data.
TransUnion Interactive.
What's that?
TransUnion Interactive.
Yeah, there you go. So, we think we're getting the real data, but it's technically another company. Now that has advantages, and this lawyer that I was taking some training from, and hopefully I'll be able to do a video with him. Ian Lincoln is a lawyer, been doing this a long time up in Michigan. And he pointed out, well, the fact that it's a different company, that may satisfy that sort of publication requirement, that it's been, publicized to somebody else, that these are really separate companies. But that's sort of getting in the weeds a little bit. Point is, go to annualcreditreport.com. Through December, we can get it once a week. I remember John Olsheimer is that CreditCon, the one in Clearwater, Stephen? Was that 21? I think that was 21.
It was last year. Yep.
Or maybe he even said this beforehand. Might have been in 2020 he said this. Maybe at the CreditCon in 2020 that I think was virtual. He said, I think they're going to just keep extending every 7 days you can go to Annual Credit Report. So far, he's been right. It's supposed to expire March of 21. Then they said, oh, it'll go to March of 22. Well, now they've extended it to the end of 22. And I think he's right. I think they'll just keep extending it. And so, but whether they do or don't, right now we can take advantage of it. And so I would definitely use that when you're plugging stuff in. Now, if for some reason you can't get your reports from the bureaus, you may have to use a monitoring service. But just understand you might then have to kind of do another round of disputes using the information from the results of investigation. And so if possible, use annualcreditreport.com, but sometimes you have to use what you have. You have anything to add to that?
You got it, man.
All right. Bryce, thank you for that. You're very welcome. Let's see here. If car dealer gives you a price estimate menu to sign, is it a binding contract?
Usually they say that, because I used to be the finance guy, usually on there they'll have language that says this is not a firm offer or a contract. Now, John, if it does not have any language to that, let's kind of answer from that perspective. What would you say?
So what we learned in law school about what a contract is, it has to be an offer. I'll sell you this mug here or whatever, this flask. I'll sell that to you for $10, Stephen. And then you say, I accept it. So we have offer and acceptance, and then this weird legal term called consideration, which just means I give up something or I do something I'm not obligated to do. So like I give up ownership of this, you give up the $10. That's a binding contract. And but I suspect on there, like Stephen said, it'll say like, this is not a binding contract. This is an invitation to begin negotiations or something like that. So
you are invited for this dealership to bend you over the barrel. Let's just start the talks here, right?
So
Sorry,
here
John.
we have a fabulous person that if you could Venmo them some money, Stephen, I'd appreciate it.
This show is always great.
Who is that?
This show is always great. We love that right there.
So let's see here. We've got, if you send a 2-page letter to Midland, can they use the excuse it was too long and we did not see the refuse to pay? The short answer is no. Okay. Particularly since they send these like legal size papers, like the really long papers and they're front and back. But there is no rule that somebody only has to read the first page. If you have somebody arguing this, just say, hey, would that work with the IRS? Because I got a 20-page thing from the IRS. I only read the first page, so I'm not responsible for anything else.
Well, John, let me ask you, because there's some esteemed attorneys in our little circle here, and they're like, no, we just want to keep that super short and simple when we send those refuses to pay, because we don't want there to be any gray area when we have to argue this before Judge Wapner. So from a practical perspective, do you have any input on that?
Yeah, I'll say this. A refuse to pay, which is the same thing as cease communications, you really shouldn't have a whole lot else in there. Now, if you take the Mike Cardoza, who's a very good lawyer from Southern California, his approach is like literally all it will say is, maybe I don't know who you are, or I don't know why you're collecting this. I refuse to pay this debt. I don't mind putting in there that I dispute it. Now, Mike would not do that. He and I take different views on that. But here's what you don't want to do. You don't want to say, hey, validate this debt, send me all these proof, and by the way, I refuse to pay. Because now that's a contradiction. Because on the one hand, you're saying, send me information. On the other hand, you're saying, do not ever contact me again. Well, now we're doing what the credit bureaus do, which is they say this over here, and then they contradict themselves. And so, the cleanest thing is to just make it very simple. I refuse to pay. Maybe, again, this would go against Mike's advice. You might say, hey, I dispute this debt, or I dispute any debt that you have, and I refuse to pay you on any debt. I put it to you this way. I sue on that, and they pay money,
There we go.
Don't.
So here it is. You can hide that clause in the middle of a 2-page letter, and John Watts is saying, I got this. Hold my beer. Is that what I'm hearing?
No.
Oh, no? Okay.
Let's see. So we got J-Lo. I disputed an item was charged on my credit card. Chase to dispute all my credit reports. I lost 20 points because the item that was disputed. Is that accurate? So I guess I'm wondering, did the credit card account get deleted? And if let me just bring this up. Just because there's a negative item that has errors does not mean we should dispute every negative item that has errors.
Well, she's not saying this was a negative item. So it may be, so she's saying, I think J. Leo is saying that there was a credit card transaction. So this would be more like a credit card transaction dispute, like was the FCBA, Fair Credit Billing Act.
Right.
And then so if the trade line then was marked as in dispute on the credit report, disputed trade lines no longer affect the score. So if this was actually a positive trade line, if this was a credit card you had for 5 or 10 years, and it's showing up as in dispute, one reason why your score may have dropped 20 points is because by it showing in dispute, it actually is excluded from the score. That's kind of what I'm taking from this, John.
Yeah, I think you're right on that. It's similar to what I was getting at, that we may dispute something that may be an actual error on our credit report. Let's say I have a 20-year-old Capital One card and there's a 30-day late that has some errors in it 5 years ago. Well, I'm not going to dispute that, because that one little 30-day late, it would be highly unlikely that would, you know, overwhelm the benefit of having that 20-year-old credit card, you know, that has a zero balance or whatever. So the dispute status should come off when they finish their investigation of the Fair Credit Billing Act. And this is an example of what, I don't know, J-Lo, if you were on when we were talking about, sometimes an account will say disputed, and we need to undispute that. We need that dispute sort of comment removed from our account. So some judges would say you need to go to, example, Capital One and say, hey, take that dispute notification off. You may also need to then dispute through the credit bureaus and say, take that off. And so hopefully that helps. If we missed your question, just let us know. All right, let's see here. 50,000, about 3.5 years in collection, Amex, trying to get my life back. Appreciate the direction. Well, you're very welcome. And yeah, I'll say this. Most of us who weren't born with a silver spoon in our mouth, we've been, you know, on top of the world, and we've been kicked to the curb. And it's actually a pretty small distance, you know, one medical event, one job loss, you know, and your life can change. The good thing is, if you keep pushing through, there is light at the end of the tunnel. And every day that goes by, typically that negative stuff gets a little less negative for you. And so just keep pushing on that.
Yeah, and I wouldn't pay them. I mean, you know, at that point, I mean, it wouldn't make sense to pay them. And if they haven't sued you this long, I mean, they could. It's before the statute expires. But I mean, I would say it probably wouldn't make sense to throw good money after bad. If it's just out there simmering, I probably would not pay it. And then if you pay it, it's actually going to lower your score because you're going to have recent activity. So from a credit reporting perspective, paying it could very well lower your score. And, you know, they may not sue you, and then it expires beyond the statute and you're good anyway. Not saying that that is absolutely going to be the case. I mean, they could sue you, but it's, you know, you got a lot of variables to consider. But like John said, just keep on chugging and you'll get back on track.
Yeah. And one really important thing is, going along with what Steven said, get with the consumer lawyer in your state to find out what statute of limitation, what does Amex do, what do those other creditors do, because it varies state by state. And so we've got Laurie, good afternoon. We've got thought it was live. Well, we, to my knowledge, are live. And so, yeah, this is not pre-recorded. There'll be a recording of this, but we are, let's see, a minute 37 or an hour 37. Which means, Steven, we probably need to wrap this up in about 20 minutes.
Man, we're just getting started over here, John. What are you talking about?
All right. So I'm going to make you disappear here for a moment. So let's see. I find cases where there are errors on the annual credit report and the client hasn't suffered damages. And I might say, let's be careful with that assumption. I've sent copies of the accounts and credit reports. Now, one or two bureaus would delete it. One bureau would ignore the dispute. I send certified with proof. If the client doesn't suffer direct damages, could there be a case, or does it not make sense because there's no actual suffering? So what I would say about that is, and you do have to know what the law of your circuit, so the circuits are over several states as far as federal law. So where I practice, the 11th Circuit, Alabama, Georgia, Florida, we have certain law on emotional distress. The 7th Circuit, which is like Indiana, Illinois, I think Wisconsin, they have a stricter law on emotional distress. So you have to know where you are. But a lot of times we think of actual damages as being economic damages. That's a part of damages, but that's not the total of your damages. So you might pay a higher interest rate, you might get turned down for a loan. Yeah, that's important. But also the emotional distress. You know, how upsetting was this to point everything out and the bureaus, or maybe it's just one bureau, ignored you. And there's case law. I'm not saying this is universal, but it's certainly the trend where courts are saying, hey, Stephen, you only sued Experian, and you pointed out that Equifax and TransUnion deleted this. That's some proof in the minds of some judges that Experian did not do a reasonable investigation, because if they had, they would have done like the other two bureaus. So I think that your client probably does have damages, and there's really, let me just say this, you mentioned something about direct damages. We have compensatory, or another word is actual damages, and that's all we have. We don't have direct and indirect. We just have damages. It might be economic, might be non-economic, but I would, get with the lawyer in your state who does this and see, hey, do you think my client has damages? Can they do something? Because I'll just tell you, if that person lived in Alabama, the disputes were done properly, and two bureaus fixed it, one bureau didn't, I would absolutely go after the one bureau.
Well, one thing I want to say, and that's Amos. Very good question, Amos. So really, I don't think there's a reason why your client should not be able to apply for credit. And there's going to be two outcomes. Either they're going to get top tier financing, which means, okay, there really are no damages, or they're going to get adversely affected. And this is really a big thing that the lawyers and John want to see. They want to see, they really want damages. They don't necessarily want to argue like emotional distress or whatever. But so what I would say, Amos,
actually, I do.
Okay, well, there you go. plus financial economic damages, right? So, but what I would say, take this client, send him to creditcards.com, have him try to apply for a top tier credit card. He's probably going to get declined. If he gets, the Amex Black, Titanium, Platinum, well, then guess what? Maybe he doesn't have a case, right? Because where are the damages, right? Or have him apply for his mortgage after the dispute, right? So what I would say is the entire basis for your frustration of no damages, you can very easily eliminate that and put your client in a much better position to talk to a guy like John. Say, hey, we went through this, and we went through the dispute. Two of the three deleted it. Then my client tried to apply for a credit card or a mortgage, and here's how he or she was adversely affected. There really should not be a reason why you couldn't run a client through a credit application, honestly. And that takes care of, John, correct me if I'm wrong, but that basically eliminates the whole, my client doesn't have potential damages, frustration. Is that fair to say?
Yeah, I'll say this. Among the lawyers that do this, there's kind of a difference of opinion. Some lawyers send every one of their clients after the results of investigation. They send them to get credit. Other lawyers don't. The argument for doing it is it establishes economic damages. It helps with emotional distress. You get that publication. Okay. The argument for not doing it is, well, does that look like the lawyer, is sort of creating this? I think the solution to that concern is your client has a right to know, can they get credit? And they see this error on their credit report, and they may say, like, I've had people say to me, I could never qualify for a mortgage. And I look at their credit report, I'm like, yeah, you can get a mortgage. Oh, no, I couldn't. Yeah, go to, Sally, the mortgage broker, and they get their mortgage. So sometimes, we may assume we can't do something. Well, you don't know till you try. Okay. Now, personally, I don't have people apply for credit that they're not interested in. Like, if they don't want to buy a house, I'm not going to send them to get a mortgage. Okay. If they don't want to buy a car, I'm not going to send them to the car dealership. But most people want to get a credit card. And the one thing you need to match up is make sure that Capital One or Amex or whoever, they have to pull the credit bureau that you want to sue. See, it doesn't necessarily do any good for if Experian is the only one with the negative thing and they pull TransUnion only. Well, that doesn't help.
So, John, I want to make sure I'm understanding this. You said there's kind of two trains of thoughts with the attorneys. Some of them like to send their clients to get credit. Others don't, and they're a little afraid because it looks like they're. How would you describe that? Why would they not want to do that?
Just that it looks like, your lawyer sent you to try to increase your damages.
Gotcha. So is that kind of like if I were to have committed a murder, John, and came to you and I'm like, John, I committed a murder. And you say, well, Stephen, did you hide the murder weapon? And I say, no. And then you say, well, Stephen, have you considered hiding the murder weapon? Is that kind of the same kind of a thing there? Like, I mean, because I don't understand why that would be a problem, buddy.
You know, I don't do criminal law, so I'm not sure, but no, you know, I'll say this about the credit bureaus, the furnishers. If you don't apply for credit, they'll criticize you. Steven, you didn't even apply for credit. If you apply for credit, they go, well, you just applied because you knew we'd messed up and you wanted to make your case better. So it's like whatever you do, they're going to criticize you. So yeah. I think it's better to make sure that your case is solid. And again, you know, if I had a client that said, I never want to apply for a credit card, an auto loan, a mortgage, okay, then don't apply. But most people are like, well, yeah, I'd like to get that, you know, Southwest Rewards card or whatever it might be. So, you know, I'll say this. I've had a lot of cases where there was no application for credit, and with emotional distress and punitive damages, 6-figure settlement. So it's not a requirement to get a credit denial or even apply for credit, but it certainly can help. Okay. So let's see here.
John, let's do a review of my credit report. My goodness, I've been having a tough time sleeping lately, and I don't think it's because of my 1-month-old newborn. I think it's because my credit score may not be perfect. I'm distressed over here, buddy. Figure something out.
You know why you're distressed? And this is the first time and only time I'm going to do this just for you, because you're that guy.
Thank you, John. I appreciate you, buddy.
Yeah. All right. So where's statute of limitations from the state you open the card or currently live in? Typically, kind of the easy answer is the state you live in. The slightly more complicated answer is the credit card agreement may say, for example, Capital One may say the law of Virginia applies. And then it gets into this complicated legal issue based on, does your state allow that contract to dictate another state's statute of limitation? And so it's not necessarily where you opened it. It's typically going to be where you live, or maybe the law of the state that the contract itself says applies. So let's see. Drew just got in to see the end of this. Well, you thought, and now we've been going on like another, 50 minutes. So
we just keep going like the Energizer Bunny here, man.
All right, let's see here. That's not by. Oh, this is on the kind of the card dealership where they give you sort of a I think she called it a menu, not binding. They have to refund you. Had similar issue when I worked at a dealership. AG ended up cracking down. Yeah, so there are lawyers, consumer lawyers, that they typically describe themselves as auto fraud lawyers, and they like their greatest joy in life is suing dealerships. And I promise you, there's an auto fraud lawyer in your state, and they would know the answer to this. Let's see, Muriel. Hello, good to see you, Muriel. So, okay, that's a hard one, and I'll be honest, I don't know the answer to this. I'm really interested in what Steven says. What about inaccurate child support?
Well, I would get something to try to demonstrate why it's inaccurate. I think you can get something from Matt Leistrow talks about this. The officer in charge. I'm not like a child support expert, but I think if you have child support, there's like some officer or somebody you can go to and try to get a report of what's going on and a status. Try to get something from them showing what the current status of it should be, and then you would want to submit that with the dispute. And then to juice it up, if it really is inaccurate and you've got that support, put it in the form of an affidavit, send it to the bureaus and saying this is inaccurate for the following reasons. And if they don't fix it, talk to a guy like John. But getting that firsthand information from your local state, I think that would be important if it really, really is inaccurate.
Yeah, and the complication is the money may, and I don't do family law, but it may in your state go to the court first, and then it may be distributed to the, like your ex-spouse with the child. So it may be like, well, I paid this, but it hasn't actually gotten to your spouse, your ex-spouse. So it can just be a little complicated. But yeah, if you can get, whether it's the judge or some agency that maybe handles the child support to give you a printout, then that could be very helpful. Let's see. Is there a pattern to when lawsuits are filed against you? I had some in the first year, second year seems slower. So typically original creditors, in my experience, if they're going to sue within the first year or two. The debt buyers, depending on your statute of limitation, they may wait a little longer. Maybe you have a 6-year statute of limitation. Capital One is unlikely to sue you at year 5. They're going to sue you year 1 or 2 typically. But Midland Funding or LVNV Funding might sue you at 5 years. Again, whatever your state statute of limitation is. Let's see. Do you send letters certified mail with tracking, or do you send them regular mail, Steven?
Yeah, you want to definitely put some sort of a tracking number on there. I mean, it's good for you. Well, I guess let me back up for a second. I mean, pre-COVID, you knew that they reinvestigated when they sent you the results, right? So like there really wasn't the argument of, well, did you reinvestigate? Because they were pretty much like clockwork sending you the results. So it's like, you sent us this thing after 30 days, clearly indicating you reinvestigated. So we know that you received it and you did something. But really ever since COVID, it's even more important to send it certified because half the times they don't do anything with it, or they don't do it within the statutory 30 to 45 day time frame. And the only way that a guy like John can raise that really as a valid claim if he were to sue would be to be able to demonstrate, well, here's the Postal Service receipt number. So, I mean, I'd say it's kind of a decision up to you. I mean, I'm sure John would say use it every time, every single time. But I mean, especially now with the reinvestigations being inconsistent, there's definitely value to doing some sort of a tracking number, whether it's certified or just regular tracking.
Yeah, and look, there can be, depending on your state, kind of a somewhat complicated argument related to a legal concept called the mailbox rule. Yeah, I just broke it. I did that twice now. But you've made me self-conscious.
You're that guy now.
Yeah, I'm that guy. I'm that air quote guy. The mailbox rule basically says if you properly address it, stamp it, put it in the mailbox, it doesn't come back to you, we presume it was delivered. Equifax says we didn't get it. Well, maybe you can allow a jury to decide did they get it or not, or you could just send it certified and get their signature. And so that's what we do. We send it certified. If you do it online, so let me just say this might be a good time to say this. Send it certified, keep a full copy of everything you sent. Don't have a Word version on your computer and then say, I think I probably included this document in it. Have a full PDF version of everything you sent. I use certifiedmaillabels.com I upload the PDF with all the attachments. They send it out. You can do that. You can do it yourself. Just keep that full copy. If you do it online, get a program. It's a software in the cloud program, Loom, Loom, and that will record your screen. So if you're doing it online, you want to record your screen because just like in my view, the bureaus, maybe I won't say they lie. Maybe I'll say they're terribly confused about receiving your documents. Well, if you do it online, they may say, we didn't get anything from you, or that's not what you told us. But if you have your screen recorded with Loom, or you can even use Zoom, we all have Zoom, just do a Zoom with yourself, record your screen, share your screen on, Safari or Chrome or Windows or whatever, and just show exactly what you did. Like, hey, I uploaded this document. They said they got the document. If you do it by phone, every bureau I know, when you call, they say, hey, this is a recorded line. Okay. Record the call. And now you've got proof of what you said to them. So you want to not only prove that they received your dispute, but then what was your dispute? I mean, we've had companies say, we didn't get your letter. And when we prove they did, they go, well, your letter said we were the nicest company ever, and they were just thanking us for being the greatest debt collector ever. Like, really? That's not what we sent you, And so just understand these companies will lie, so protect yourself. This is what they do. They can't help themselves. All right. So let's see. So here we have an inquiry. I was pre-approved for an installment loan. They emailed me the contract. I declined it. So if you, the short answer is no. I don't think that you can, because they had the right to look at your credit report to decide whether to make you the offer. Even if they chose not to make the offer, they still had the right to pull your report. And if you choose not to do it, well, they still had the right to pull the report. Really, the only time that matters is when they pulled your report, do they have what we call a permissible purpose? And if you're taking a loan out, I think they would. Let's see. Here's an interesting question. So, Steven, why don't you answer this for credit repair? Do you still run your own credit repair place?
Yeah.
And then, so maybe answer it either for yourself or for the CROs that you advise, and then I'll answer it as a lawyer who does this type of work.
Well, I mean, I guess, let's see, how should we answer this? Because there's so many ways you can answer. I mean, I don't think people have been negatively affected due to COVID. If anything, if you're running a business, there's a lot more business from what I've seen in a lot of the CROs that I deal with. Number one, there was all that stimulus money that was pumped out there. So people, had money to spend on things, but still people were getting behind on stuff. And so people need credit. If you're out there running your business, I mean, things had slowed down for a bit, like in 2020, just when the economy was shut down. But now you've got people trying to get those accommodations, as far as, hey, we talked to the furnisher and they said that they were going to waive my payments, and they didn't. So, I mean, I've, probably coached over 400 CROs since 2020, John, in our training course. And, if you're in business to be in business, there's business out there, I guess that's really my answer, is if you're out there and you're trying to put relationships together and you're growing your business, the business is definitely there for you. And now more time than ever because of the financial issues that we've had. So I guess I'd like to know, Eric, I mean, feel free to shoot me an email or a message. I mean, if you've got something specific that's on your mind, I would love to talk to you, because if you're trying to grow your business and you're not finding that there's opportunity out there, that's kind of a conversation, I think, to have with you to help you figure out how to overcome that.
Yeah. And I think that, well, let me back up. I think it was Ronald Reagan who said economists have predicted 8 of the last 3 recessions. Okay. So with that sort of warning, to me, it feels like we not are facing very tough economic times. I think we're in them, but we're right at the beginning. Inflation's out of control. I mean, we're seeing the stock market, massive decline. All the people you hear crying are the people that, bought Bitcoin really high and, have watched, like, in 48 hours, 30% be knocked off. We've got really an unprecedented housing bubble, in my view, that's going to pop and be just devastating. And so I think particularly with that, interest rates rising, I mean, unless the Fed loses their nerve and decides to let inflation go completely out of control, they've got to keep raising the interest rates. So it's going to be very, very difficult for people to navigate financially. And so it's going to be even more important to have good credit. And so I think there is going to be a greater need during these upcoming difficult times to make sure their credit reports are accurate. So Eric, if you're running a credit repair business and you're not, getting the inflow of customers and clients, that's a marketing issue. And, talk with Steven about that. There are some guys in the Facebook group that are very, very talented at that. I know Shiva does that marketing program, and then
with Joe Chavaria, he's a
really Joe good and who's his partner, Alex.
Yep.
I mean, those guys are like, matter of fact, they have a YouTube channel. I think it's like Credit Repair Marketing, something like that. I mean,
yeah, I think you can YouTube Joe Chavaria. I think he's, you'll find him. He's down in Houston.
Yeah. So those guys can really help you about, how do you approach loan officers, real estate people, auto dealers? I mean, the work is out there. It's just a matter of getting it into your business. Marketing is to make your phone ring. Selling is to close the deal, so to speak. And so, from my standpoint, there is greater interest in people wanting to fix their credit reports than even before the pandemic. So, and I think that's going to continue. Let's see here. Amber says, shout out to Kim. Okay, so now we know the name of Better Body Crew. So she was on here very early in this epically long YouTube, Facebook Live.
2 hours. Can you believe that, John?
So,
My goodness gracious.
So thank you, Kim, for inviting people. It's very nice of you. Let's see. This is interesting. Patrick says, Santander consumer reporting negatively for 4 years. The loan was paid off. So I guess my question would be, think of a timeline. So you paid it off. Are you saying that before then it was negative? Or are you saying after you paid it off, they're reporting negative? And are they reporting like new negative stuff? Okay. In other words, if it was charged off and you paid it, it can still say charged off. It should just say zero balance, paid off. But sometimes what we see is we pay something off here, and then the next month, next year, they're reporting like currently being late. And that is definitely something I would be looking to dispute those errors. Let's see here. So you are very welcome. And there we go. There's Kim. So thank you again, Kim. Let's see. They won't remove old addresses. So what's been your experience with that, Steven?
Well, there's 2 ways. So number one, like we talked earlier, you can send in an affidavit. The other thing, actually, if you go online to the Bureau direct portals, you can dispute addresses online directly. TransUnion, if you dispute only the addresses, you'll actually get like an instant result right there. In other words, if you dispute the addresses without a trade line, Equifax, you'll usually get a response within a few days. Experian, they actually won't let you dispute addresses online if they're attached to a current trade line, but if they're not, you can do that. I see a lot of good success with doing the online address disputing, but if that doesn't work, you don't have the ability to do that, put an affidavit and say, this isn't my address, or this is not my current address. And like John said earlier, please ensure that, people don't use this address because I don't want mail to go here. It could cause identity theft and all that kind of stuff.
Yeah, and my rule is 2 years. So if I moved last month, I'm not expecting the credit bureaus to get rid of the address I had a month ago. But something that I haven't lived there in 5 years, why is that on my report? 20 years ago? I mean, why do I want a dozen phone numbers that are not my phone numbers anymore? Somebody else will answer those phones. Those don't need to be on my report. So, but if it's something very recent, I give them a little bit of slack there. But stuff more than 2 years old, I think, get rid of that. Let's see. Kim says video on this issue TV provider. Okay, that's the Direct TV, and so we've got some videos on the YouTube channel about that. And Patrick says, thanks. You're very welcome. Let's see. Is it normal for credit bureau lawyers to offer lowball offers like $500 for major violation of FCRA statute of limitations? So the short answer is yes. It is common for them, particularly if you bring the case without a lawyer. They will look to settle those sometimes $250, $500. Sometimes you'll sue them in small claims court and they will remove it to federal court because it's much more complex in federal court. And usually they can trip you up on sort of the rules of court. I would just say this: if you have a case that has an actual violation of the law, you really need to bring that with a lawyer that does this type of work. I mean, the lawyer is going to get attorney's fees. All it's going to do is magnify the total amount of the recovery. And, look, if a UPS truck runs a red light, hits you, totals your car, you miss some time from work, I wouldn't advise it, but you could settle that without a lawyer, because a lawyer, you're hoping the lawyer will add value to it. Well, with the FCRA or FDCPA, the lawyer should add value to it, and they get their attorney's fees. And like our minimum hourly rate on these consumer type cases, not that we charge our client, but that the bad guys we sue have to pay, is $500 an hour. So we spend 50 hours, was that 25 grand? I mean, so it's just, there's no reason to bring these cases without a lawyer. Now, so with this exception, sometimes the answer is it's not really a case. And that may be why everybody's turning you down. But I would just make sure you have solid violations, it's properly documented, and then, go to the consumer lawyers in your state. If you have a problem, send it to me. I'll take a look at it. And sometimes it may just be the way it's being presented to the lawyer. You may be telling them everything right, but they're just sort of, their background is interpreting what you're saying in the wrong way. So if you have lawyers turn you down, just reach out to me and I'll be glad to take a look at it. Let's see. Yeah, so there will be a replay, but we are still live right now.
Still live. Can you believe that, John?
Yeah, maybe not for long here. Enjoying your banter as an additional layer to receiving great information. Well, it's I'm sure this is obvious, but in case it's not, literally this is how we prepare for the show. Usually about 3 minutes before we're live, I get a text like, "Where's the link, John?" I'm like, "Oh yeah." And so I invite Steven, he gets on and we're like, "Hey, how you doing? What are we going to talk about?" "I don't know. You ready to go live?" "Yeah, let's go live." So there is not a whole lot of thought, but
well, the reason being, John, is really when you're an expert like you and I are, we've been preparing our entire lives. So when we go live, this is basically what we've been training for,
Yeah. And I'll say this, all kidding aside, we genuinely do dislike each other. No, I mean, we like each other, but, we like to sort of take shots at each other. So
that's right.
It's all usually in good fun. And, I may shed some tears later at what Steven said.
I mean, I'm just saying, John, for a guy who gets paid $500 an hour from the bad guys, what would think you could at least afford a necktie? I mean, I'm just saying, man, what's going on there?
I'll tell you what, if I'm walking out of a court, unless I see a judge coming, I'm like tearing that tie. I hate ties.
Taking it off, huh?
Let's see. We got High Better Body Crew, and then hey, so yeah, I'm glad y'all are connecting here. And let's see. Mother has a home in Fort Lauderdale, Florida. Home was paid for, then took out a HELOC, 160. Loan sold 3 times, hasn't moved, still 160. I mean, if it hasn't been paid, I would think it's a lot more, but there are maybe some statute of limitation issues. I would get with, in Florida, Aaron Swift, who's in the Tampa area, Clearwater, or Mike Waslick, who's in the Tampa area, specifically Dade City. And those guys know about, mortgages in Florida and really good consumer lawyers. And so I would check them out. See, A says, have an apartment default judgment from June 2017 out of California. Moved out the proper way, approved by apartment manager. Returned to Florida 2017, never knew about till 21. Everyone refuses to stop the default. Address the court and clerk refuses to file my motion to dismiss or motion to vacate. What should I do? So I would say this, Ace, you need to get a lawyer in California. You might reach out to Mike Cardoza. I don't know that he would personally be able to help you, but he would say, hey, go call so-and-so. If you weren't properly served, then in every state I know of, that would be a basis to vacate the judgment. But you've got to put that evidence in that motion, okay? And that does get very state specific. So it would be California. So call Mike Cardoza. If you just look him up, it's Cardoza Law Group. But Mike Cardoza in Southern California, he'll help you. Let's see. Yeah, this is a great question from Patrick. So if trade line comes off one bureau, do the others have to remove it? What do you say about that?
Well, technically, no. However, if it's inaccurate and you put them on notice that's inaccurate and it remains inaccurate, it should have been removed.
Yeah, I agree. So if business service papers at the wrong address, judgments rendered without you knowing, in, I assume that's South Carolina, for best solution notary courier, what can you do? So again, the answer on anything related to a collection suit, get with a lawyer in South Carolina. There's a lawyer named David Maxfield in South Carolina, and a lawyer. She used to be in Alabama, then she moved to South Carolina. Her name is Penny Hayes Colley. I would get with either one of them. Either they could help you, I bet, or they could tell you who could help you. And basically, you would challenge that. Like if you were in Alabama, this happened in Alabama, I'd say, we file a motion to vacate. The judgment is being void because we weren't served. And here's the proof we weren't served. They served at 123 Main Street on that date and time. I was in California. Here's my plane ticket. Here's, or I was in the hospital, whatever it is. You want to prove it was impossible to be served. And I mean, we've vacated judgments from like 17 years in the past. Okay. If you weren't served, it's no good, at least every state I know of. But get with those lawyers in South Carolina. Do you sue third-party debt collectors pursuant to the Privacy Act, either or as common law tort? We sue for invasion of privacy. That's a common law, state law. I'm not familiar with any specific Privacy Act that we would sue under. You have any thoughts on that, Steven?
No, you got it. But if you can sue for invasion of privacy, I mean, where is that authorized under the FDCPA? I mean, I guess if the FDCPA was constructed as a statute to cover debt collection, does it state in there like you can also use other common laws? Because I would think that the debt collector would say, if it doesn't, well, this has been legislated, so you can't do anything except for what the law that legislates this subject matter says. So is it spelled out in there that you can, it doesn't exclude other causes?
Right. So I forget the exact place. Usually it's at the end of this relation to state laws. It'll say something like, does not affect any other laws. Basically, state law can give you more rights, but it can't give you less rights than the FDCPA. Now, the FCRA is different. For the most part, the FCRA says we get rid of all state law. But FDCPA says we're the minimum and the state can go above it. So I may have to bring that up a little bit higher. But, state law is not inconsistent if it affords the consumer greater protection than here. So if we go back, it says, let's see, subchapter does not exempt anybody from state laws except to the extent they're inconsistent. And then inconsistent means less protection. So yeah, you can do state law. And so like the guys in California, Florida, they will sue a debt collector under their state version of the FDCPA. So it's the FCCPA in Florida. It's a Rosenthal Act in California. And but we don't have that in Alabama, so we use sort of good old-fashioned common law, just what's called invasion of privacy. Let's see. Called Chase, told them to cancel the dispute because it was resolved. Shouldn't Chase notify the CRA? They should, but there's no liability for Chase as a furnisher of information unless they're notified by the credit bureau. Now, here's where it gets a little complicated. The credit bureaus may argue you have to go to the furnisher first, but if you go to the furnisher first, then they'll say, well, that means that you're not liable. So, like, they'll argue both sides of it. Typically, if you call, like Chase, they'll take care of it. Or if you contact the credit bureau, I don't have it, but there's a phone number. I know one time I was getting a home mortgage and I had a dispute notification. My broker called me and said, hey, you got to remove that. Here's the phone number. It was really easy. Just call up. I go, hey, remove that dispute. And I'm sure Matt Listro has that. let's see here. Moonlight as a comedian. So dry humor. Wait, you are very, very kind. So let's see here. Yeah, we got, appreciate everybody inviting friends here. So can you give any advice on LCI? I don't understand anything about how this company works. Is LCI, is that a public records vendor, Stephen?
They are. Yeah.
Okay.
I think it stands for like Lundquist International or something like that.
Okay.
So I guess the question would be, if you don't understand how it works, where is your question about trying to understand how it works come from? Probably because there's all these people out there talking about freezing these alternate credit reports. I'm going to assume, Raquel.
Probably for
Which
bankruptcy.
I don't buy into that at all, because freezing a report only keeps them from preparing a consumer report. It does not keep them from furnishing data. They're playing dual roles if they're a furnisher and a FCRA. So, I mean, the only other reason you would need to worry about LCI in the real world is if they prepared a consumer report and you were adversely affected, right? So in that case, you want to get that report and you want to figure out what's wrong. But I mean, so they are a consumer reporting agency that also furnishes data, similar to LexisNexis. That's kind of the high level on LCI, I would say.
Yeah, the only thing I would add to it is if they are a credit bureau, rather than freezing, just get a copy of your disclosure, your credit report. See what they're reporting. Is it accurate? Is it inaccurate? And I would just maybe modify some language Stephen said. They are a credit bureau, and they also can provide information to the bureaus. They're not, when they're providing like public record information of bankruptcy, they're not really a furnisher like we normally think of a furnisher. They're really, the law would call them a vendor. Just like they could hire Bob to go down to the courthouse to pull the court record. That's what LCI does. Now, they may also be a credit bureau. And so you can freeze them all day long, but that doesn't stop them from going to the courthouse, writing down your bankruptcy, and then providing that to Equifax. So, but if you have something more specific, just let us know. So, got thank you. Well, you're very welcome. And we have our friend Better Body Crew. And Marianne thought I was watching a replay. Well, you know, it might be. We may have looped around so long.
I mean, it's 2 hours and 17 minutes. My goodness, we're about to. I think Zuckerberg is going to kick us off here soon. Probably we're sucking up too much bandwidth.
We're gonna blaze through these really quick. So, sent letter right to child support for $49K. They deleted, stop garnishment paycheck. So, okay, I think I'm understanding that to mean you sent the information that showing that this wasn't incorrect, maybe.
Yeah, it looks like she got the child support corrected, is what I'm seeing here. Looks like it. Good job, Marianne.
Yeah. So Jimmy says, what do I do if credit acceptance is denying consumer law? It doesn't apply to that. So probably what that is you may be saying, hey, the FDCPA, Fair Debt Collection Practices Act applies. And they may say, no, we're not a debt collector. We're an original creditor. And that may be true. And so it may not apply. But if they are reporting on you, then the FCRA applies. Now, if they're not reporting, the FCRA would not apply. So just have to figure out what law you're talking about. And then we always show that law applies. So like people say to me, hey, John, this is a great FDCPA case. And I go, well, tell me about the debt collector. Oh, it's a great case. Don't get bogged down in details. I'm like, was it even a debt collector? And then, well, is it a consumer debt? Well, I'm sure it is. Well, maybe it's not. So we got to kind of make sure each law actually applies here. So here we have another default judgment. You have to use an affidavit to get the case scheduled for court. That's going to be really based on your state law, the procedure. I'm not familiar with anybody needing an affidavit to get the case scheduled. Now, they may have to have an affidavit to prove at the default hearing that you actually owe the money. But, Andre, I would just get with a consumer lawyer in your state, and they should be able to tell you that, answer that question very easily for you. So we got Richard and our eminently popular Kim here. Let's see. After I paid it off, sent a copy of the check. Okay, I think that maybe goes back to Santander or car loan, I think. So, if you pay something off and then maybe it's not reporting correctly on your credit reports, it's always good to show that proof that, hey, this was paid off. Let's see, webinar machines. Well, we're about to break down here. So great info. Let's see here. Trying to grab the rest of these really quick. We're going to lightning quick here. Collection agency call, left a long message saying they're getting a judgment and garnishment. No idea who it is. They called his wife, left same message. Should I dispute or get an attorney? I would get an attorney. If there's not a lawsuit filed, that should be a violation of the law. It almost sounds like this is more of a scam debt collector that you may not really be able to find, but definitely get with a consumer lawyer in your state. Let's see. Here's one for you, Steve. Jayla's asking Muriel, is it true about paid medical bills will come off reports in July of this year?
That's what I'm reading. There's the bureaus are going to start to do that, which is interesting because those are typically the simpler items to dispute, the low-hanging fruit, as they say. But as my understanding is, they will be. Yeah.
Yeah, and I will say this: I've heard different people say different things about, well, what does paid mean? Does that mean you paid 100 cents on the dollar, or can that be it's a $500 medical debt, you settle with them for 200? Is that considered paid? I assume whether you paid them a penny or everything, if they agree now you no longer owe them, I would take the view that that means paid. But I was talking to a consumer lawyer at NCLC who provides all these manuals that are really helpful, and she said no, it means like you have to pay the full amount. And maybe that's right.
We don't want to use her then, do we, John? We don't like her position.
So here we have Jonathan, as always. Thanks. Well, thank you, Jonathan. And Kim Betterbody invited me, and I'm grateful. Well, we're glad you're here. Marianne, when they left on the wires, it was the same message for him.
Hold on a second, John. I mean, I got to say, all you guys coming into John's YouTube, you need to go to the Steven Palmieri YouTube channel as well and like my channel. Give me some love. I've only got like 50 subscribers. John's got like 20,000. You gotta love the underdog over here, peeps. What are we doing, man?
Yeah, let me see if I can pull that up. Let's see. No,
John's a machine when it comes to pulling things up and doing screen shares here. When I first met John, he had like 17,000 people on his YouTube. I didn't even know the dude had a YouTube channel. I just said, who's this guy with the funny twang who talks like I do? And then I realized he had a YouTube channel, and I'm like, oh wow, the guy's like an influencer. Look at that, man. And then here we are doing this show together, isn't that? See, look at that. How many?
Yeah, there's that guy.
Oh,
I've got that guy.
I've got 101 subscribers now. Look at that, man. My goodness, I'm in the three digits.
Yeah, and I would say this, particularly for the credit repair people, watch this interview with Brian Ponder. This is, if you're in credit repair, you'll know about Credit Repair Cloud and CFPB suing them. And
look at that. I got 5 whole views on that one, John. Man, you got to start somewhere. You know what I mean?
Yeah.
It doesn't say 0.
Absolutely. So I put it into the chat also. So,
all right.
Mary, on your thing, again, I would just get with a lawyer to listen to those messages, look up the company, because it sure sounds like it violates the law. We just need to make sure it's a real company. And we've got, thank you, you're very welcome. And search for that video. I think that was on the cable or direct TV. And thanks. So who do you recommend in Texas for FDCPA cases? So
yeah, I think it's Warren Maxwell. Chris Ebert, he's got a good firm, John Helstowski. Chris Ebert, I would reach out to him. Let me know. I can get you connected over to him. He's got a pretty good firm that he works. He's not a lawyer, but he's teamed up with a really good firm.
Yeah, so you could use him. There's James Foley in Fort Worth. There's Bill Clanton, not Bill Clinton, but Bill Clanton. And I want to say Bill is in San Antonio, maybe. And so there's some good things there. Oh, wait a minute. How do I get that off the screen? Mike Cardoza's the man. That's painful to see, but I guess we'll leave that up there.
That's Jeremy Roberts.
I was actually supposed to see Cardoza, so I'm out in Phoenix, and Blaine Dixon and Aaron Swift, a lot of people are out there, and I was getting on a plane as Mike was like landing, and so we missed each other. So Mike's a great guy. See, Patrick, if we moved out of state, that account that was open, do you file in the state you live? If you're talking about being sued, typically they'll sue you where you live. Technically, they could sue you where you open the account, but normally they sue you where you actually live now.
So like you could go from one of these draconian states that have like 7-year statutes of limitations and then move to like a state that has like a 3-year statute of limitations and then be like, dude, it charged off 3 years and a day ago. You guys can't get me. Is that what I'm hearing from you, John?
Probably. So Patrick, hey, thanks for the questions. And here is our friend Kim, 70% of medical soon be removed. Yeah, so the paid medical, and then sometime next year, maybe like March of next year, I think accounts that are at least right now they say it's going to be a minimum of $500. I think even if they're unpaid will not be on credit reports. But the point is what Kim's saying here, there's going to be a lot of medical debt that's removed, and a medical collection account under some of the scoring models is just devastating. It might be a $20 account and it may drop you 100 points. It's insane. So this is actually kind of getting things the right way. And we use 1099 to set off mortgage, save us from foreclosure. What's the best way? I'll say this, Natalie, I'm not sure. If you're talking about if you received a 1099, sometimes we can argue that means we don't owe the debt. But when you're talking about a mortgage, they have the security interest, which is the property. So that usually won't protect you. But get with the foreclosure defense lawyer in your state, because, I mean, like foreclosure defense in Alabama, totally different than Florida, different than Georgia, different than Tennessee, different than Mississippi. And we're all, surrounding states. So let's see, my buddy Jared. Good to see you, Jared. Let's see. Does Experian treat ID theft block requests as a standard dispute? No. Well, they should not.
Yeah.
If you sent like the police report, the FTC affidavit, I'll say this: if somebody does this and they're truthful, then Experian's got to block it. Okay. Now, Experian, I suppose, can take the risk and say, well, we don't believe you. And if it turns out it's not true, they're okay. But that's a really, really risky game for.
Let me help you out there, John, because you're kind of duty bound to this code of legal ethics. You can't ambulance chase, solicit things like that. But Mr. Martin Powers, let me say, if this in fact is a truly legitimate ID theft, and Equifax told you to go pound sand twice, make a beeline to Mr. John over here, and then he will team up with an attorney in your state, and then he'll get him another 6 figures off of it. John, at least just send me Uber Eats, okay, once we get that settlement. So
I'll send you some fries. How about that? All right, let's see. I had to move out of my apartment due to mold. Both kids came sick. Can I get back the money they charged me? So I would get with a landlord-tenant law. You want the one that represents tenants. So again, it's a consumer lawyer, but very few lawyers do like all of this. I mean, there are guys and gals that just represent tenants, and they're going to know, like in Virginia, what the law is, what you can do, what you can't do. So definitely do that. Let's see. Oh, this is on that Privacy Act, Title V. Just have to look at that. Sometimes the statute may say one thing, but then the court interpretation sort of gut it. So I just, off top of my head, I don't know. Mary, great, thanks. You're very welcome. Where can I find the fair market value is for a car that was repoed and sold? NADA,
NADA online and Blue Book as well. Those would be the two
Yeah.
sources. Or Black Book. There's actually Black Book is what a lot of dealerships actually use also.
Yeah, and that can be very helpful because most states say a repo that then is sold has to be done in a commercially reasonable manner. Well, if the Black Book or Blue Book, is $10,000 and they sold it for $500, that's a pretty hard argument for them to make. Let's see, unpaid rent by state and federal program considered debt collectors, purposes of being right. So that's a good question. I'll say that like an SBA loan typically is not considered consumer debt. And there are just some weird things like taxes in the 11th Circuit, last time I checked, are not considered consumer debt. So there might be a debt collector, but the FDCPA doesn't apply. Like you drive in Florida, you get a toll booth violation. That's not considered consumer debt usually. So it's kind of surprising. You just have to look for your particular type, and there's probably a case on that. See, Maria says she will, and I think we are almost here. Well, more than I thought here. Let's see here.
Dude, the questions keep on coming. I think our audience is testing your resolve. You said 30 minutes ago that you were getting ready to wrap it up, and they're like,
yeah, I know.
See you guys. Right. You're going to shut us off. I think
we're going to go with like 10 seconds here. On my way. That's great. Okay, this on that Privacy Act. So yeah, we'll just have to take a look at that. So that's good. Marianne, you're very welcome. Martin, what happened 4-day block rule? It's still there for identity theft if you properly dispute that, and that's a very serious thing. They need to take that seriously. Going overtime for us. Well, you're very kind, Kim.
That's right, Better Body Crew. Go to Steven Palmieri's YouTube channel. Give me some love.
Thank you, guys. Well, you are very welcome. Oh my goodness, Kentucky's 15-year statute of limitations. Yeah, you need to go across the Jordan River into the promised land of Indiana. It's got to be a shorter thing, or go south to Tennessee, something like that. So, would you classify third party new acquired apartment? I'm not sure about that. Let's see, Natalie, thanks. You're very welcome. And then, do you have a partner in Kentucky? I don't. I have a lawyer that I work with in Tennessee named Blaine Dixon, and Blaine literally knows everybody in the country. I sort of tested it. I had him come to Alabama, and we had lunch, and he starts talking to the server. It turns out, like, the server's best friend grew up with Blaine. I'm like, what in the world? I mean, Blaine Dixon knows literally everybody. So he would know somebody in Kentucky for you. So you can just Google Blaine or send an email. He actually has an email at my firm, blaine@wattsherring.com. And
or Marianne, you can send me a Facebook message and I'll connect you.
There you go. Yeah. There you go.
That's right. That's right.
All right. Let's see. Bank account closed with bogus code. I mean, just the bank account itself, if you felt like they violated the contract, there's almost always an arbitration agreement. You can file arbitration. If you're talking about like a check systems or some type of credit report that you think there's an error, then you dispute it through the bureau. And let's see. Oh, apartment complex management company debt collector for purposes of unpaid rent. Usually not, unless that's their principal business purpose is collecting defaulted debt. Let's see. Should have more than 5 likes. Well, thank you. And you're very welcome, Rick. And J-Lo, you're very welcome. And here's the last one, Marianne. So we will end it with that.
John, hold on.
You got something?
I hate to be that guy, but I just had to point out to everybody that Marianne said, "Great, thanks, Steve," but she didn't about John.
I know. I'm hurt. I'm just hurt.
Marianne, you're asking John all these questions. Does he know attorneys in Kentucky and statutes of limitations and child support? John's a sensitive kind of a guy. You should have at least thanked him. But I can't blame you for just thinking of only me. I am amazing as well.
Your star shines so bright, Steve, that I'm.
That's right. That's right.
If this was done by authority and notoriety, certainly, like, my window would be really tiny and yours would be so.
Well, I must say, 2 hours and 34 minutes. I think this is a record, and I think we've made up for all the shows we've missed and skipped for our audience over here, man. My goodness.
Yeah, well, we're going to end it on this note right here.
Oh, Marianne, that's not you. I didn't see that. Come on now.
You're very kind, Mary. So, hey, thanks, everybody. We enjoyed it, and we will see y'all hopefully in a couple weeks here.
See you guys on the next show. Appreciate it.
All right. Have a good one.